Hey, what up, jerks? We're live right now. Mike Crawford, day one of the Karen Reed retrial, and we have the best guest. I can't wait tonight. And what I'm throwing up right here is our new domain, a new website that we have now. Our email, newsletter, blog, whatever you want to call it. www.midnightmassnews.com. Going to be posting a lot of more written content there. It's pinned in the chat right now. Definitely subscribe. We just put a Karen Reed. We posted a bunch of different YouTubers that we liked. We posted even some internet lawyers where you could find your Twitter lawyers. One of them we're going to have on the show tonight. So check that out. Put your email, subscribe. It's pinned at the top. I also have one programming note before we bring up the big guest tonight. We do have the super chats on right now. We turned them on off the last couple times because it got crazy. No questions, no expectations on the super chats. We're gonna read the super chats and the Venmos and the Cash Apps at the end of the show. That's when we'll acknowledge those. So if you have a question, just post it in the regular chat tonight. We'll try to get to it. So let's bring up the guest tonight. Wicked excited to have him back on the show, Attorney Mark Bederow, and this is day one opening statements for the defense and the prosecution. And no one I would rather have more on the show. People are already missing Mazza. We are missing Mazza. Definitely missing Mazza tonight. But we have a great guest here. Very glad to have him back on the show. Attorney Mark Bederow. Welcome back to the show, Mark.
How are you? I hope I'm not in that list of what you call Twitter lawyers.
You were.
Twitter
some
lawyers.
readers noticed it. They got a chuckle out of it. It was kind of a joke. It was
I hope so, because
I listed all these YouTubers, everybody. I listed every Melanie Little, all the lawyers. I had the locals, I had the nationals and the international YouTubers. Then I was like, I have to list Bederow. Like even we listed the show listing on it, but I had to list you, and it was like, he's a Twitter lawyer. And then I put Nan there too, because she's also a Twitter lawyer. And you guys are like two of the biggest guests on all these shows, so we had to link you up.
I just used the term Twitter lawyer, not in a nice way, with some of the Twitter law school graduates. But okay, whatever.
It's your phrase. I love it. If I could throw a Bederow quote in there, like an Easter egg, and then the readers, like the one dude who figured out first what was going on in the comment section, he wins today. Like he got it right away. So there we go. It's fun. So Attorney Mark Bederow, watching today this Karen Reed trial. Like we were talking to the green, like where do we even start with this? This is wild that we're even doing this, but not a good day for Hank Brennan, I guess already. What are your opening thoughts for this opening of the Karen Reed retrial today?
Yeah, I think they had a pretty tough start. I don't think the opening was particularly effective for a couple of reasons, and certainly coming out of the gate with their first witness being Nuttall was a curious choice and frankly a disastrous choice. But when Brennan was doing his opening, he was making Nuttall like the anchor of the case. I mean, what a strange way to come out of the gate and start about the bell going off at the station and responding, and the hero of the story is firefighter Nuttall, who seems like a nice enough guy, but he's not a very credible witness. He's not a reliable witness. I don't know that he's affirmatively lying. He's certainly trying to help them, but he wasn't reliable a year ago, and he sure as hell is not reliable today. The cross-examination of him was, very effective. He has no credibility. I mean, I wouldn't rely on him for any fact that you need, just based upon, all of his inconsistencies and whatnot. There were no real bombshells in the Nuttall got sacked. That's kind of funny. There were no bombshells in the prosecution's opening. It was impressive if you are impressed by lawyers who kind of move around the courtroom and, don't use notes that often. That's a good thing. But the risk of doing that is you screw up the facts, and he kind of did from time to time. But his tone was very flat. I was a little surprised. It was monotone throughout. And on substance, there really wasn't anything that was dramatically new. I mean, anything that he tried to put out there as impactful and new, I thought was rebutted more than effectively by Alan's opening, which in contrast was very spirited. He was very invested in it. And of course, I was pleased just because it was all about reasonable doubt and driving that home again and again. And that's, in my view, that's the right approach, always has been. And it was really powerful, really effective. And for people who didn't know what was going on in terms of what evidence would be from the first trial to the second trial, he previewed a lot of interesting facts, which will be very hard for the prosecution to deal with. And in some sense, it feels like Brennan actually walked into head first, leading with his chin into one of those key points that the defense will establish through credible testimony, which is upon impact, John O'Keefe would have been rendered unconscious and certainly incapable of doing anything, which I think you'll find obviously will be significant given the timeline of the events that occurred on his phone. And if he was rendered unconscious, he couldn't be playing with his phone, and that could foul up the whole timeline that the DA wants to use to try to argue that this had to be the time the car went in reverse and whatnot. And the fact that he kind of walked himself into was pretty shocking, because if I understood him correctly, and I'm pretty sure I did, he seemed to indicate that not only was John O'Keefe not rendered unconscious after getting hit and ending up in the physical condition that he did, but as if he was kind of spun around, wandering, maybe dazed for upwards of 20 seconds, but during which time he decided to, see who's texting him and manipulate the phone in several different ways to open the phone, close the phone, and then just collapse and, in essence, lead to his death. That made no sense to me. That's a hell of a bridge to try to cross and convince people. The other thing that I thought was very fascinating was the previewed medical condition that the defense will offer about the lack of frostbite, the lack of hypothermia, which would substantially support their timeline. They are saying that the phone temperatures will actually, which Brendan tried to make a big deal out of, implying that John O'Keefe must have been out in the cold all that time, that the defense is saying, no, it's actually going to support what we're going to say. They were very confident about him being moved there and being placed there. And they did all of this without really even mentioning the ARCA stuff, which, they weren't allowed to for reasons I'm sure we'll discuss later. But I think that when you factor in how the openings came off, understanding that the prosecution has the burden of proof, seeing the styles of the two lawyers, and then you got to see at least one witness's testimony right out of the gate. You never want to start with a weak witness, and for whatever reason, the DA chose a weak witness. They knew he was going to be a weak witness. They put him up first. They opened on him again as the anchor to this whole case. That made no sense to me. All I kept thinking was, what the hell are they doing, and why would they be doing it like this? So it's only one witness. There's a long way to go. They're only about halfway through, I guess, Kerry Roberts and her direct. She doesn't look very confident, frankly, or comfortable up there, which is a little different perhaps than the last time, or maybe looks less comfortable. It looks more forced, looks a little more contrived. So I thought they didn't have a good day other than, playing the video, which I guess to some extent, maybe they think dilutes the impact of Nuttall being such a disaster about whether I hit him or not. But if they think that the road to a conviction is going to be playing clips that are taken out of context or based on memory that may or may not exist, or whether she said, did I hit him or I hit him, whatever she said in that video that was played before in between the two witnesses, they're going to need a lot more than just that. And, they have a long time to try to do that. But if an opening is their chance to preview that and really impact the jury, I'm not sure they did.
It's a question. Did they have any impact on the jury? Because first impressions,
you only get one.
Say like the most important thing. So today was the first impression. You can't get that back.
Yeah, I mean, you only have one chance to make a first impression. It's the first time the jury gets to see at least some of the lawyers. And I mean, today was the Brennan and Allen show. They haven't even seen any of the other lawyers. Of course, the jury's going to learn very quickly that Brennan's on his own. And again, for most of the day, and if I can see it on TV, the jury can see it, Lally is staring at the judge's bench like he would rather be having a root canal than be sitting up there. And it's just obvious. The other prosecutor wasn't even there today, which was interesting. First day of trial, and she wasn't there. But, the defense is going to roll out some other lawyers too, so they're going to get a chance to have a few more first impressions. But certainly the takeaway in terms of the lawyers' styles and effectiveness today, this is why none of this surprises me. I mean, I think Allen is certainly the better orator by far, and tactically he appeared, at least today, to be head and shoulders. I mean, I thought the substance of his opening was more effective, and he used the burden of proof advantage very well. Brennan not mentioning Proctor at all was a terrible mistake. You have to be credible with the jury, and warts and all, you have to kind of sometimes let the air out of the balloon in advance and then explain how you're going to look away or work away from it. And to not even mention any of that and give the defense the opportunity to say, how come he didn't mention this? And then just roll right into all of the problems. I mean, I thought that was just a tactical error. I'm not sure why he did that. I'm sure he had his reasons. Obviously, Proctor is a problem for them, but you can't run away from the problems. You have to deal with them head on. I mean, you have to be credible with the jury. And I would be concerned that wasn't exactly very credible.
Good question right here about what does Mark think about that back and forth between AJ and Nuttall with the video clip and Nuttall insisting his version still happened?
Painful. I mean, in some ways pathetic. Nuttall doesn't strike me as a bad guy. He obviously is on the team. He's trying to help the team, but I don't look at him as one of the bad guys, even though he just thinks that's what I have to do. But to listen to him even before, I mean, you have to look at the whole examination in a whole before you get to the whole nonsense about the video. I mean, this was a guy who tried to say with a straight face that my memory today is better a year later than it was a year before, which also just happens to coincide with the fact that he sat down with Brennan and Tully and they helped him correct some of his testimony, and now he has a better memory. Now, that's not a good look. I mean, that looks, from his perspective, that it's not his memory that's better, it's the power of suggestion that's better. They had you review your testimony and you're just going with, or other evidence and you're just going with it. The part about the video was just painful, and I get why Allen stuck with it. I think you have to. You have to make the point you have to make, and if the guy won't admit what you would think, somebody in high school would recognize what needs to be admitted, the simple concept that when you described Karen making these statements and, you're in the position of putting the oxygen mask on and the other guy is giving chest compressions, that we're watching a video which appears to show the whole time the guy's on the floor giving chest chest compressions and Karen's not there, then that doesn't appear to be on video. It says, no, but it's on the earlier video, but the earlier video doesn't match what he had already said. And as I was watching this testimony today, and you can tell, lawyers can tell how it's being set up, where this is going way in advance. And the thought I had was listening to Nuttall, what he was saying, knowing where this was going, that rhetorically speaking, not literally, that he was already dead and he didn't even know it yet. I mean, and I'm talking like 30 or 40 questions before he ultimately got exposed as being not credible, that he had already gone so far down the rabbit hole that nothing he says was going to be credible. And, you know, even the stuff with his statement of Proctor, and that's kind of a lose-lose for the DA, right? Either you blame it on Proctor or this guy's not reliable. Does it matter which at this point? So, yeah, I mean, I just thought the video thing was pathetic. Sometimes you have to keep at it, though. And I think the judge was wrong to try to shut it down. At some point, it may discredit what the jury thinks is powerful testimony. If they believe that Karen said, I hit him 3 times. So you have to let him challenge that. And he has a good faith basis to do it. And just because the witness wouldn't give it to him the first time around with kind of a really nonsensical explanation, it's no place for the judge to say, well, I'm not going to let you do this again and wrap it up. That's what you do when somebody's doing a cross-examination that is on a minor collateral issue or you're just wasting time. This is on a critical issue about whether the jury should credit this guy's claim that he heard Karen say, I hit him. And then if that wasn't enough, as you later learned, only on redirect, he claimed that I heard him say it to other people as well. And the only interesting thing about that I thought might have been a missed opportunity for the defense was when Nuttall tried to say, well, I'm only mentioning it now because nobody asked me before, which, by the way, that's kind of like a flashback to Jen McCabe type answer in the first trial. When he said that, what I thought Alan was going to do was go back to the prep sessions with Brennan and Tully about all the things they talked about and whether he had said it then. Because if he did, how did this not come up on the direct testimony if the testimony would be favorable for the prosecution, which ostensibly it would be, which is I hit him, and I heard it again. Why wouldn't they ask him that? And the logical answer is because he didn't tell them that. That did come out for the first time on redirect for some reason. And it would have been and he says, well, nobody asked me. If the jury had heard, well, okay, nobody asked you, but you did tell Brennan and Tully this before, yet they didn't ask you on direct, it's not very believable. So that was the one thing I thought maybe that they just left. But on the other hand, this guy was so discredited. I don't think in the grand scheme it would matter too much.
Sometimes quit when you're ahead.
Yeah, I mean, I think that was like worth getting into. But again, he's not a reliable witness. You know, you have the puffy coat incident from a year ago. You have the alleged statements to Proctor that initially he said, I don't remember, but then he said, no, I'm going to go farther and say, I didn't say it. He changed his testimony about I hit him or how many times she said it after he spoke to Brennan and Tully. The video doesn't show what he claims happened with the I hit him. I mean, you could just go on and on. He's just not a reliable witness. And he also had terrible body language. It's very rare that you literally see a witness get hot under the collar. Literally, he was literally tugging to get air into
There's a lot of memes about that tonight.
I didn't see any of that. But literally, he was hot under the collar. He looked uncomfortable. That's not a good start if you're the prosecution.
I like how he couldn't remember things, but then he could remember other things.
Yeah, well, he certainly remembered. He remembered the first go around last year. About all of that, but he couldn't remember some really important things. I mean, look, he wasn't a great witness last year. He wasn't a great witness today. The part that I just can't wrap my hand around is why would you do an opening that begins centered around that guy and then call him first and make the first day of the trial the Nuttall day? I mean, this is the kind of guy who, even as far as the firefighters go, should be one of the least significant ones. I get it. He's going to say, I hit him. But, the other ones are going to have problems too. Like when you get to McLaughlin, I mean, everybody knows what she's going to be subject to. And none of these people wrote it down. None of these people, none of the cops wrote it down. I mean, this is not the kind of thing that is going to get cured by playing a video after he testifies where, Karen said what she said. Now, that's not good for her. Don't kid yourself. That wasn't helpful. But the idea that somehow takes I hit him off the table as a discredited issue for these defense witnesses, that's Twitter law school. That's not the real world. What she said or didn't say under the heat of the emotion and then talking about it a year or two later and saying, I don't remember what it was or how many times it was this or that. It's a fair point for them to make. I thought it was clever for Brennan to introduce it at that time, right after, which also demonstrates he recognizes that his first witness was not good, because why else would you do it right then and there? But, I don't think Kerry Roberts is going to be, a very good witness when all is said and done. So I think it's going to be another rough day for them tomorrow. The odds of her not getting cross-examined, like was the case in the first trial, I would say are a lot closer to 0.000% than they were the last time. And I don't know what witnesses they have lined up after that, but it just seems like a very clunky rollout for the new and improved prosecution team.
There's a lot of talk in the comments about ARCA. It's weird because most of the feeds ended. They thought that the hearing was over, but later on, Bev came back, and I think it only aired on Zoom. But it basically was Bev going after the defense about ARCA.
Yeah, I mean, look, they're continuing to whine that, we can't try the case because we don't know what ARCA is going to say in the form of a new opinion that includes an analysis of the aperture or the Welcher, the prosecution reconstruction expert opinion. So they're complaining that that's unfair and therefore they shouldn't be allowed to do it. And it's another one of these gaslighting examples of these outrageous discovery violations by the defense. And then what you saw in response to that, when you saw Bob get up there, and I mean, a lot of people thought, make sure he doesn't have a stroke, because he was pretty fired up there. But he made a very compelling argument that it's very unfair to blame the defense for discovery violations that go past the deadline that the judge sent. When they get a report at the very end of January, they immediately try to line up ARCA through the feds. They get them. But the real issue is, they have a month to turn in all of their expert discovery, but they don't get a usable report or information from the prosecution. So they had to change some of their slides. They made substantive changes. And the ARCA guys are saying, we can't use this. We can't analyze this. And Brennan continues to argue that it is somehow a discovery. It's not fair. It's not fair. So you shouldn't allow them to do this. They're hiding text messages from me with all of this. So none of this is fair. And it just goes back to what we talked about probably last week, which is, if you're worried about your expert getting torched by the other side's experts, knowing what their opinion already is, then you must not feel very confident in what's happening here. And the idea that the judge would actually determine that these witnesses can't testify is absurd. She can't do that. That would be, in my view, a serious issue for possible reversible error if there was a conviction. She already harmed the defense by not allowing them to name them in the opening, although I think they handled that pretty well, getting around that. But, she wouldn't let them get into that. And now they're going to waste Friday and have to haul these people out here to, have another voir dire about their communications with the defense and what were you doing when you were talking on the phone. And these are all things that have nothing to do with anything. It's, they're doing the hearing on Friday, so it is what it is. But there's just no way that she can keep these witnesses out. This is just more busy work. She continues to conclude that the defense is somehow hiding evidence or doing things that are improper. If there are text messages that were deleted from a couple of years ago that are much ado about nothing, as Bob was saying, they're gone. What do you want to do? They don't exist. I can't give you what doesn't exist. And, Brennan will say, well, wait a minute. I need those text messages where it may very well be, Alan and Doctor, whatever his name is, talking about how do we lie so we can fool the jury about what it is. That's not what it's going to be, right? And they don't exist anyway. So there's nothing to disclose. It's enough of this. The short answer is put them on the stand. They're going to give their opinion. And it's common sense to expect that part of their testimony will be, did you review the prosecution's expert report? And how does that impact you? And you saw the prosecution do this at the first trial in reverse. They did it with their cell phone experts. They did it. I think they did it one other time. This is really not that big a deal. And it's very rare that you would see a prosecutor whining, saying it's not fair to us that we don't know what the defense expert is going to say. We know their ultimate opinion, but we don't know how they're going to supplement that after they have analyzed our expert. Therefore, you shouldn't even let them testify, or there ought to be some kind of punishment. This is silly, really.
He just filed a new motion too. I don't know if you saw that.
I did. They must have filed it earlier in the day, and they basically said, let us voir dire, or, we need a new trial date till June or something, which is never going to be granted. This is not going to be a summer trial. That I'm pretty confident that she would never allow. I've just never seen. He's trying to tell the judge, we can't continue if you allow this. That's just disingenuous. That's just an oversell and more gaslighting about all the discovery violations, again, without any self-awareness of not only the historical discovery violations related to the video, but if you listen to what Bob was saying, they got like a one-page report. They didn't get the real data. Then they had to get this report with all these slides, and some of them were not even correct, or they weren't usable, and they had to be changed. And by the time, if you listen to Bob carefully, all of a sudden you're into like mid-March. What are they supposed to do? The trial date is now. And they still don't even have all the data they need to get an opinion. So how are we blaming them for getting a substandard report from the prosecution to give to their expert and turn it around? So again, this is all just gaslighting and whining.
Comments and questions coming in too tonight. There's one right here from Sarah. She says, actually, she wouldn't be able to allow it anyway with a new jury, right?
Well, jeopardy has attached. Once the jury is sworn, jeopardy has attached. So that motion you saw today about, we want to adjourn the trial, that clearly had to have been filed in the morning before the jury was sworn. Because if you think this jury is sworn and the prosecution would say, we want an adjournment until June, which would result in a mistrial, that would be too risky because they may be blamed for that mistrial, which could kick in double jeopardy and prevent a new trial. So at this point, the jury is sworn, the trial is on, and the idea that she'll exclude these witnesses that are central to the defense and are entirely exculpatory, it can't happen. I mean, she can't do that, especially over this kind of ticky-tack complaint that Brennan is making, which is, I need to know what they're going to say so that my expert is prepared. They have an expert report, okay? They were able to look at the ARCA report. It works both ways. I understand what he's saying. Well, we have a right to their discovery and their report, and there was a deadline, but that deadline was arbitrary. It was just a date the judge picked. There are extenuating circumstances. There's no reason that the judge in her discretion just can't say that I find that the defense is acting expeditiously. There's no problem here, and I'm going to allow them to do this. And if you need a day, Mr. Brennan, off so you can review whatever, then you can do that. But the idea, again, that somehow they're going to punish the defense by excluding these witnesses or not allowing them to say anything about the prosecution report, I mean, that's just silly.
Ashley, who says, so will this voir dire be for the discovery issue only, or will Brennan get to question about their opinions too?
Well, I think she had previously reserved like the classic Daubert hearing for them, even though they don't need it. I think the hearing that she envisions on Friday was for the discovery stuff to see, are there going to be sanctions here? And if so, how severe will they be? I mean, she continues to believe that the defense is deliberately suppressing evidence and hiding things. And I think that's just unfortunate. I don't know why she thinks that, especially when you heard Bob's explanation, which I think was very well reasoned, just the timeline, the chronology of events. I don't know what else you expect them to do. They can't disclose what they don't have, and they can't give over a report that hasn't been prepared because they don't have the information, because they don't have it from Brennan's own expert. I mean, what are they supposed to do? So the idea that they're going to drag them in Friday with no notice, waste time, waste money on, tell me how many times you spoke to the defense and how many times you text messaged and what you did. The irony is the defense could not get an evidentiary hearing on the motion to dismiss with really well-pled, real egregious discovery and Brady violations, but the prosecution can get essentially a mini similar hearing on a moment's notice, hauling in witnesses from out of state in the middle of trial to grill them about discovery violations. But the stuff in the pretrial hearing isn't worthy of the court's time. That strikes me as kind of crazy.
We're getting lots of comments, apparently. Usually, I should have mentioned this earlier tonight. Usually we do the Canton Select Board meeting. Instead, we're not doing it tonight. We're not airing it. I was hoping LTL Media might do it. But apparently, they're just announcing at that Canton Select Board that Chief Rafferty, the Canton Police Chief, that was going to be probably a lot of discussion about renewing her contract, especially with this Select Board election that just happened, with someone campaigning against renewing that contract and winning big. I guess Chief Rafferty, the announcement tonight is she's going to retire, which is, wow, surprising.
I don't know. Is it? I mean, I'm not obviously big into like local Canton politics. I mean, I'm aware that the guy who was like the boss hog of Canton, who's been that guy for what feels like 50 years, finally got thrown out on his rear end by quite a margin. Could that lead now for the police chief to read the tea leaves? Maybe. Does that make other members of this select board read the tea leaves? Probably. So the fumigation may be starting in Canton, which is not a terrible thing, clearly. But I don't know what it means in the grand scheme about the trial, but I think she's probably just reading the tea leaves. And yes, retired does sound better than fired and all of that. And, I don't even know how old she is or whatever, but it doesn't surprise me. I mean, clearly the town finally decided on some level they want change when you toss out Boss Hogg after all those years. I mean, that's just the way it is.
Good question here from Dollface. She says, does Mark believe the advantage of the jury being able to see the witnesses in the small courtroom outweighs how close the McAlberts are to both Karen and the jury?
I hate that courtroom. I fully understand the need to have a courtroom where the jury needs to be able to see the face of the witnesses. Body language matters. I don't know why they've had that nice courtroom in that condition for all those years and nobody seems to notice until now, or nobody cares until now. So I think they made the right choice because witness demeanor, body language is very important, and it's their position that a lot of these witnesses are lying or just have poor body language. And I mean, I'll give you a perfect example. You've had two witnesses so far. Neither one has had great body language. Nuttall looked very nervous, very uncomfortable, and again was pulling at himself and looking over, and he didn't give off any degree of confidence at all. And you look at somebody like Carrie Roberts today, she did not look comfortable either. She looked, I thought, nervous, little mealy mouth, stressed. Um, and you want to be able to see that. I do think, however, being in that tiny little courtroom is terrible, where you have, the O'Keefes right across from the jury, right on top of the defense table. It's not a great look. I think it would be better if you had a more classic courtroom where both sides are behind the well of the court, kind of left or right side, whichever is which. But I mean, there's no choice. I mean, they're all cramped up there at that table. It looks like crowded as hell. But what are you going to do? I mean, there's no choice.
There's no choice. That's it. That's it. Yeah, we so many good questions coming in tonight. I want to thank everyone who's been asking questions. Let's go to this one. This is about Kerry. Emma says, "What does Mark think?" Kerry saying that Karen said he's dead. I don't recall her saying this in trial one.
I think it's going to be a rougher road. I mean, she didn't even get cross-examined the first time. So she was able to say whatever she said. And I think if you go back and look at her transcript or, watch the video, whatever it is, on many levels, there is a lot of meat on the bone with her that I fully expect that they are going to come swinging hard tomorrow as it relates to her. I think her story in certain levels appears very rehearsed, very coordinated, perhaps with her friend Jen. As far as this about saying he's dead, I don't remember exactly as I'm sitting here right now whether she said that, but I just thought a lot of it today sounded very contrived. I mean, she kind of threw out there and it came out very clunky today. This, Bella's mom or whatever, and it had no context. It was just kind of like thrown up out there, just like it had been rehearsed and just like remember to say this to somehow suggest that Karen was jealous and whatnot, and that's just on direct, and it just feels difficult. She looks uncomfortable to me, and the story is not flowing, and I think it's going to be very interesting to see how she comes off because she has not been cross-examined like the rest of them, and we'll have to wait and see.
Go to this one because you mentioned, already mentioned kind of the poor choice of the prosecution open up with these two witnesses. But a lot of comments coming in like that's all they have. That all they have is what Karen said. It really, uh, Jarea says, who will be the good witnesses for the prosecution? Who should they have opened with? Maybe.
I don't know. I mean, look, I don't think it's not a case I would prosecute as a prosecutor. It's just so it's kind of hard to say, here's what I would do. I mean, I understand the concept of a first responder or a police officer. It's very common in a criminal case to have responding cops kind of start and lay the foundation of what's going on. And in this case, the firefighters are the first ones to respond. The question I have is, why the hell this guy? I mean, he's the worst of them all. If you put aside the McLaughlin Albert thing, which may or may not be effective or not, depending on how the judge handles that. But if you remember from the first trial, he was clearly the weak one. I mean, it's not just that he said he had a puffy jacket. Okay. He said, I remember it vividly because I had to like take it off and cut through it or whatever. And he said, I'm positive. And in the grand jury, he said that's what he had, like 3 layers. And at the trial, he said, I'm as certain about that as I am about anything else, as much as I am about, she said, I hit him. And, you know, everybody knows that. I mean, not only did John O'Keefe not have a, you know, Michelin Man puffy jacket, like I think it was called or something like that, or Stay Puff, whatever. He had on a very thin long sleeve hoodie, but not even a sweatshirt, a thin shirt with long sleeves.
Jersey hoodie.
And so he could not have been any more wrong, which is bad enough, but he could also not have been any more adamant last time in saying, I damn well remember that as much as anything. And then today, when he's changing his story about little things and he's saying, it's after I met with Brennan, it's after I met with Tully, and then my memory today is better than it was a year ago. I mean, this is...
happens to nobody.
Why this guy? I don't know. Why is this guy the one that Brennan hitched his wagon to in an opening that, again, I think it fell flat? I mean, look, he's obviously a skilled lawyer. He's working on memory to some extent. He's well prepared. And a lot of lawyers in an opening, I get it. They want to tell a story and they want to start with something that's going to grab the jury. For example, in the first trial, you know, Karen Reed was framed. That grabs the jury, obviously. Okay. Coming out and saying she was not hit by, John O'Keefe was not hit by a car. He was not hit by a car. You know, that right away, for whatever reason, the little vignette that Brennan wanted to start with was this really cheesy, flat story about a firefighter who may very well be a nice guy, but has zero credibility. He's not a reliable reporter of what happened on the scene that night. And to make him the hero of the story, it's just weird to me. I mean, I don't know what the hell he was thinking. And so I don't know who, I mean, maybe one of the other firefighters or maybe one of the police officers. The fact that they're calling Kerry now, does that suggest that they don't want to call other firefighters? I don't know. I mean, it's an interesting way to proceed. I don't know why they're doing it this way. It doesn't mean it's wrong. But if you wanted a first responder and you wanted someone to say, I hit him, I hit him, I hit him, I don't think Nuttall was the right guy for that because you knew he was going to get destroyed on cross before he ever stepped foot in the courtroom today. And you don't want McLaughlin because that's a terrible way to start. And as you saw in Alan's closing, his pregnant pauses for all the people that are, friends are named Albert. That's Albert, very,
yeah. I love the way he says Albert too.
It's the pregnant pause. No, I mean, it was done. That's how lawyers do it. Well. But I don't know. I thought the opening, it was interesting and it, to some extent, I mean, he got a lot of facts wrong. He came up with that crazy story about, John O'Keefe wandering and then collapsing. And it's just fascinating because this morning I got stuck watching. I needed both of my regular computer screens for other stuff, so I had to watch on classic TV, like the actual
Cable
TV,
television.
which means in English I was stuck with court TV because I'm not in Boston. I can't watch it on local whatever. And if you watch court TV's analysis of what was going on when Brendan was giving his opening, you would think the trial was over, and it was the most masterful performance that Julie Grant has ever seen in her life. And ace analyst John DiPietro, the two of them were just going on and on about how masterful it was. And I think, again, his delivery method, I like the prancing around the courtroom, but there was no inflection. There was no modulation and up and down. And it got lost. It got boring. It almost became, do you really remember that much of it other than John O'Keefe checked his phone after he got hit by a car for 20 seconds and then just collapsed? What powerful points came out? We have science. Okay. The phone temperature. I remember that vividly, what he said about the temperature of the phones and why he thinks that might be important. But what else was said? He stayed away from Proctor. He stayed away from Jen McCabe. That's interesting to me too. I don't think her name was even mentioned. And if it was, it might have been once. He stayed away from Brian Albert, stayed away from Brian Higgins. And he just left that on the table for Alan to suggest you're hiding things. Like he's giving you half a story and not telling you what's going on here. And I don't expect the DA to give an opening that is a defense of the Alberts or anyone like that. But I would think there would be at least a mention to the ones that he would have believed were helpful, such as, according to Jen McCabe, Karen said, I hit him. You don't know that from his opening. All you know is that, Nuttall, and you're going to hear clips of her saying certain things. And to me, I found that just not very impressive.
I wasn't impressed. A couple comments I was seeing saying that some of the law tubers thought Brennan didn't do a bad job, which is wondering who those law tubers are. But
look, it wasn't terrible. We're here to analyze and criticize and whatever, but the affect was dull. The opening vignette with Nuttall was cheesy. And again, based on a witness that nobody wants to or is going to credit. Other than that, there was no real pathway to find her guilty. I don't think there was no real specifics. And if you're trying to grab the attention of the jury, which of these lawyers talking today do you think would get the jury to be captivated and to focus on their theory of the case? For a fact that the defense theory of the case on a primary level is what we've been bitching and moaning about for the better part of a year. If there's no car accident, there's no crime, at least as it relates to Karen. Okay. About that. About the investigation and all the problems with it and how it's all wrapped around, Alan called him a cancer. I've called him the albatross for the prosecution. It all comes back to Proctor. You weave in the butt dials, the taillight pieces, and all the stuff that they're talking about. You learn some pretty compelling things about if he was rendered incapacitated, how could that happen? And you heard all kinds of things, the no frostbite, that sort of thing, that we have a medical examiner who's going to say this. Their own medical examiner couldn't even tell you, the manner of death. It just seems to me that the takeaway from the openings are, if the prosecution has the burden of proof, they were real short on details on how they're going to wipe that out. Whereas the defense that has no burden of proof is giving us a lot to chew on already to say, well, maybe there's reasonable doubt. And then they, maybe there were some Easter eggs in there. I don't know. But there was a comment about, there will be eyewitness testimony proving that John O'Keefe went in the house. Now, I don't know if that means based upon you've heard of and it's interpretational, or does it mean something entirely different that people who watched the trial the first time, were unaware of? I don't know. But I think certainly after the openings, when you factor in the burden of proof and you factor in how they were able to speak to the jury and the points that were presented, if you're trying to help brainwash the jury to a side, I think the defense did a better job than that. And certainly, I think, as we said, Nuttall was a net loss for the prosecution. Maybe the prosecution gained a little bit when they played that 30-second clip after where, Karen's talking to the reporter off the record or whatever. I don't think it's that compelling. But I mean, the prosecution has the burden of proof. They need to do better. And they had a very clunky rollout today. It just felt surprisingly clunky and flat.
We keep getting a lot of ARCA questions. Here's one. Will Bev sanction AJ Friday and kick him off the case under grave concerns like she threatened a month or so ago?
No, because then you'll have a mistrial. I mean, and the reality is, how do you make this personal with Alan as opposed to all of them? So no, I mean, any sanctions would relate to the evidence in the case. You're not kicking these lawyers off the case. Jeopardy is attached. They're on trial. They have a seated jury. No, that's not even an option, unless you want to have another mistrial.
Which she doesn't want to. I mean, she definitely doesn't want a mistrial.
No, I don't think anybody literally wants a mistrial, but this really is much ado about nothing. I mean, there's nothing they can do if they don't have the data to give to their expert to get a report. It's, in the first trial, the prosecution made a mockery of their discovery obligations, and they're complying, or they're certifying, that we disclosed everything. Here's this. Nobody bats an eye. Okay. When the defense gets an inverted video in the middle of trial, forget the fact that it was inverted, but it just gets dumped on them in the middle of trial. Nobody bats an eye. It's just business as usual, whatever, take the lunch break, look at it, and we'll go from there. But today we're being told again and again that this ARCA thing, which is a nothing burger, is some sort of catastrophic, prejudicial thing where the prosecution can't get what they call a fair trial unless they have this. And it's just silly. Again, that's the only word that comes to mind.
Absolutely. There's this other question right here but see what I say? Everyone keeps talking about ARCA. Everyone's worried about ARCA because that's what Brennan keeps bringing up. Amelia says, if the judge excludes ARCA, can the defense do something? And I just add on to that. You don't think the judge will exclude ARCA, though, right?
No. There's no basis to, and it will be almost reversible error in the event of a conviction. So what the defense would do is make a record, a very long record, a very, close to an hour type of record, and then you preserve it and you move on. And in the event that she were to exclude these witnesses, they preserve it for an appeal. If, God forbid, if the defense came in second, it would be a very powerful argument on appeal that it's a violation of due process and your right to present a defense. And, obviously the judge can make findings on what she perceives are discovery violations, and appellate courts don't generally interfere in that unless there's an abuse of discretion. But, in these circumstances, this may very well be an abuse of discretion anyway, because they haven't delayed anything. When you listen to the way the timeline is being explained, I don't know what you would expect them to do. What have they done wrong? I'm still waiting for the court to explain what it is that she believes they did wrong. Never mind what Brennan says. I mean, nothing is fair. Everything is, I mean, he's made representations that are often not true. He did it in his opening today, on things that don't even matter. But, I think he said that the Nuttall thing about I hit him was on video. Well, it damn well wasn't. You know that because we spent like an hour and a half, it felt like, realizing that. So I don't know why the judge, other than her saying, I have concerns or I find this, there really ought to be an explanation for this because I don't know what you expect them to do. Nope, you're silent.
Mistrial question here from TJ says, doesn't a mistrial favor the Alberts? They can publicly say Karen Reed is guilty. They sway public opinion and they're never prosecuted themselves.
Well, I mean, they're probably never getting prosecuted anyway. Certainly not in this court. For what? I mean, just because there's no evidence that beyond a reasonable doubt that Karen Reed did anything, I don't think there's evidence right now that we're aware of that would warrant a prosecution of anyone in the Alberts. I mean, you can certainly have suspicions about the butt dials, the Google searches, the text chain, all the weird things that they appear to have done that people who are not hiding something or covering something up would not do. But do what? I mean, you can't accuse any particular person of killing someone when there's no proof that anyone did that would warrant prosecution. So I don't know that they need a mistrial.
Bring this one up here. From Z, they said, what do you think of Brennan saying Peggy will testify to say the O'Keefe side and didn't mention Paul or Aaron?
Well, they're both on the witness list, so he can. I would always think that the mother would make a more logical choice. I don't know why that wasn't the case in the first trial. I just think the difference is this. If you call Mrs. O'Keefe as a prosecution witness, unlike Paul and Aaron O'Keefe, there is substantive cross, which can potentially harm the prosecution because there are witnesses, McCabe and Kerry Roberts, who have said or implied that when we made our little timeline of events, that we got our heads together and wrote it all down, and then Kerry read it to the police, when they interviewed her, and the McCabe's and Alberts were texting each other while Kerry Roberts was getting interviewed by the police. The testimony was, well, Peggy asked us to do that. Now, that's weird. I mean, obviously there's been a terrible death, a tragedy. Nobody knows what happened. And you're supposed to believe that within the span of, 24 hours or so, the mother of, the deceased person somehow reached out to Jennifer McCabe and Kerry Roberts so they could sit down and prepare a timeline so we can get all our ducks in a row. I mean, that always struck me as not likely. Now, I don't know what Mrs. O'Keefe would say, but if you're the prosecution, do you even want to put her in a position where she's going to get examined and have to explain that? I wouldn't.
There's quite a few good comments coming in. Here's another I wanted to ask tonight on here. Here it is. Colleen says, Mark, do you think the judge always rushing the defense like she did today? You mentioned this earlier too. Telling them to move it along. She did it twice today.
It's inappropriate, particularly when it's on a critical fact. Now, the Nuttall thing was painful because he just wouldn't give up what so obviously would seem to be a point you concede. And the fact that he wouldn't do it doesn't mean that the lawyer is not allowed to press it and try to get him to do it. And when the judge basically said, we're not going to play that video again or wrap it up, she's signaling to the jury, this is not effective. That's giving her opinion, not literally, but implicitly to the jury that you don't need to do this or anything else that follows isn't important. When she says, I don't want you to play the video again, she's implying to the jury, this would serve no purpose and you should just accept or not accept what happened earlier. That's not fair. That's very different than cross-examining something on a point that may be less important, less relevant, and is just a waste of time, or what lawyers call a collateral issue. Okay. As far as Nuttall's concerned, if he's going to testify at all, the single most important fact, really the only fact that matters with him, is whether the jury credits or not his claim that he heard Karen Reed say, I hit him, I hit him, I hit him. So why shouldn't the lawyer defending a client in a murder case who's facing life in prison be allowed to do it in the way that he wants, as long as it's relevant, as long as it's not in any way improper? It's not the place of the judge to editorialize that I'm getting sick of this. So I thought that was highly inappropriate.
Question about the defense and Peggy O'Keefe. Says if Brennan puts Peggy on the stand, I hope the defense wipes the floor with her.
Wow.
Normally, I would say leave the family alone, but in this case, they all need a wake-up call.
Well,
Do you
so
think there's any chance the defense? I don't think they would. Do you?
I mean, listen, the family of a deceased person in a criminal case who someone's charged with murder normally is the third rail. Okay, you don't touch unless there's a reason to. So the idea that, you know, I hope they wipe the floor with her, and just because their role is not to give anyone a wake up call. Okay,
Yeah.
The role in cross examining someone like Mrs. O'Keefe is there any purpose to this that's going to help me in the case? And as I said a few minutes ago, with her, I think there may be this idea of her, Jen McCabe, and Kerry Roberts huddling up to create a timeline to help them, which has mysteriously disappeared, right? It's never been used. Where the hell is that? Why didn't that get disclosed, by the way? Another question for another day for another person. But if you talk about like Paul and Erin O'Keefe, what are you cross-examining them on that is somehow going to be helpful to the defense? You're not cross-examining Paul O'Keefe or Erin O'Keefe on, you know, issues about their personal life that came to light, you know, maybe several weeks ago, that kind of thing. There's no way that they're going to examine either one of them about that. I mean, to what end? What would that accomplish? I don't think they really have any important evidence to offer anyway, as it relates to the case. So, no, I would think that if the family testifies, and the kids as well, of course, who are named in court, by the way, if you saw, I thought they weren't supposed to be named, but they were named. They're not going to get vigorously cross-examined, and it's just, there's no the reason is it doesn't help the defense to do it. It's too risky. It serves no point. And, you know, it's not nice. And there's no reason to run the risk of looking mean and nasty just because you can. They need to be the good guys, you know?
Brings up a great point I didn't think of. Is the witness John, you know, that saw John go into the house? Does that mean Karen is going to testify?
No. I mean, you're not going to give an opening in a case like this where you essentially commit to the defendant testifying. I mean, it's rare is the case where you would ever make it clear that a defendant is going to testify. A lot of times you see that in a justification or self-defense case where the defendant has to explain their subjective and objective perception of what was happening and why they shot the guy, and because he was coming at me first. And here's, you know, you need that evidence. They don't need Karen to testify. And I don't think any of this was in any way committing to that. And ultimately it's her choice on the advice of lawyers. But I mean, I think everyone would be shocked beyond belief if she testified, if for no other reason. You know, they're putting in all these videos and they're going to try to juxtapose that against I would be more shocked if she testified in this case and probably any case I've ever seen where, a choice for a defendant to testify. I'd be stunned.
Definitely. Yeah, I would. That would be wild. That would be unexpected. I don't think that they would make that decision, even if they were even thinking about it. But I don't think they are.
You always think about it. I mean, you
Yeah.
always play it out in your head, but I mean, this is one I would play out in my head for about 20 seconds and say, yeah, no, this is,
Yeah.
first of all, there's no need. I mean, forget the risks. In a case like this, where your position is, I didn't do it, I don't know what happened to lead John O'Keefe to end up in the way that he did. There's testimony from the prosecution's own witnesses that John O'Keefe got out of the car. I mean, you're going to see that from those three kids, Heather Maxon or whatever her name is, and the Nagel kid, and the other one, D'Antonio or whatever his name is.
Yeah.
So even if you wanted Karen to testify, you would never do it unless there's like, what fact are you establishing? Why are you doing this? What are you trying to establish? And there's nothing for her to establish that they can't get from other people. And there's nothing they need to establish at the risk of having her get examined and all of that.
Go to this question about another potential witness and whether they need to call him, who needs to call him. Proctor, which side is going to call Proctor? Rocky wants to know, and will he plead the fifth?
Well, Proctor was thrown out there a lot by the defense. He wasn't mentioned at all by the prosecution. That doesn't mean they won't do it, the prosecution. But at this point, yeah, I would expect he would testify. As far as pleading the fifth, that ship sailed. My view was he should have taken the fifth before the first trial, and he didn't. And he answered all of these questions. And so he can't hide behind the fifth on the substance of what his testimony is. He's already waived it. He's given sworn testimony and been subject to cross-examination and voluntarily agreed to answer questions about the kinds of things that he would take the fifth. So that's not really an option for him. It would have been if he had taken it the first time, which, if you recall, when we talked about this, I thought he would. My advice to him would have been, shut your pie hole. Nothing good comes from this. And you do have some degree of possible exposure. And of course, when I say possible exposure, or you have a good faith basis to take the Fifth Amendment, I mean in the real world, not the Wendy Murphy world, okay? You could be Proctor's lawyer and say, I don't believe he committed crimes, but he could answer questions which could be incriminating in the hands of a prosecutor or could somehow be harmful to him, in terms of some investigation. So, but he can't do that now because he answered all the questions. So he screwed the pooch on that.
One thing I want to ask about is they're going to visit. They're going to do the on-site visit.
Mm-hmm.
Who decides when that happens? Like, is it the prosecution? Is it the judge? Is it the defense? And
they're going to have to agree, and ultimately the judge will have to decide. I mean, they have to know. I would hope this time that the defense would fight hard to do it at a different time of the trial, or say, then we're going to need 2 trips. Because the way they did it last time, by my recollection, was there was no context to the significance of it. I mean, at that point, they had a lot of first responders. That's not really relevant to seeing the crime scene. The relevance to the crime scene would have been, wait a minute, those McCabe's and Alberts were like that close and heard and saw nothing. The body would have been right here. They came out here and they saw nothing. And those 2 windows up there where you could basically open up Brian Albert's bedroom window and probably spit onto the flagpole. That's how close it is. That needs to come out and where they see the crime scene in the context of all of those things. And when they did it last time, so early in the trial, none of those people had testified. There was no context to see that. And what you saw at the time they went there were the pictures that were introduced by the prosecution, which really distort what 34 Fairview Road looks like. The way it's angled, or look, I mean, people have laughed. I don't know how to crop a picture or do anything technical. The way the pictures of 34 Fairview that the prosecution used, the impression it gives is that there's like an acre of land up there. It's a very small front yard. There isn't even a sidewalk right there. And the jury needs to see that when the defense is making hay with, how did nobody hear this? How did nobody see this? Right? I mean, they're screeching the tires, going at that high speed right outside the window. There's got to be a loud bang. You now know that, according to the prosecution, that, John O'Keefe was out there for 20 seconds. Was he making any noise? I don't know. I mean, I think you need to do it at a time where the jury is focused on the significance of it, not when it's just kind of a throw-in, which is how they did it the first time.
Question about whether a visit at night. I mean, could the defense request that, or is that out of the realm of possibility to say, hey, why not check out this site at night? Reality check asks.
I mean, that's kind of interesting. I suppose you could ask, and I suppose the judge would just say no, if for no other reason than just union logistics. We turn into pumpkins at 4:01 p.m. or 5 o'clock, and we're not doing this. If there was a way to do it, I think that actually, to see the headlights hit the lawn, or to see walking out of the house, going down the path and looking over towards the flagpole, I think that would be interesting. But the other problem you have is this: January 29th is a lot different than mid-April and early May, with the, even if the lighting, the darkness, January 29th I know it's the middle of the night, so it doesn't matter, but they're not going to the crime scene at, 1 a.m. That's just not what juries do. So even if they went at night, what time are they going? It would have to be late, because it's getting to that time of year where the light, fortunately, stays on a lot longer than the darkness. But they're not. I doubt very much they're going to do that.
Which next witnesses? Who do you think Brennan's likely to call next after we get through with the first two here?
I don't know. Look, I'm sure the prosecution will tell the defense with some degree of notice. It's hard to tell because, certainly I don't think anyone would have expected Nuttall first. And I don't think you would have thought that Kerry Roberts would have been second. So the short answer is I have no idea. You would think that they would lump the first responders together with the cops. That is a normal, logical way to set the scene. Most prosecutors then would somehow move it towards the lead investigator. But in this case, that's a problem, because are they calling him or not? So maybe that would lead to someone like Buchanan, who is the de facto lead investigator now. Someone like Tully. There's different ways you could do this, but I would think that they would just pack it with the first responders and police. But I don't know, because Kerry Roberts doesn't fit that pattern.
How about this comment here from Julia? Says, Mark, is this reasonable? Brennan exposed corruption of the feds during the Bulger, and took this case expecting collusion between the feds and the defense, and he's still sure there's proof somewhere.
I don't know. I don't know why he took the case. He'll make some money. That's good. People have heard of him when I would imagine 97 to 99% of the people 5 months ago had never heard of him. So, that's good. It's an interesting trial that you're a part of. That's good. But is he doing this because of, to avenge Whitey Bulger? I doubt it. Does he have some sympathy to the idea that, I hate the feds? Maybe. But I don't think that this is part of some plan where he's sniffing around as a Morrissey stooge to figure out what the feds are doing. I would hope he's not, because that would be pretty embarrassing for a distinguished lawyer to willingly make themselves, a hired gun prosecutor to be a stooge for that guy to sniff around what the feds are doing. I don't think that's the case.
What's with this one here? I'm not sure. Could the defense show the video that was made in that time frame that shows what you can see in the snow?
I mean, it depends. I mean, if you tried to replicate the scene on, that time of night on that time of year, of course, the other problem is you'd have to get the lighting exact, whatever was on or off. There's probably not going to be snow or not the same amount. It becomes very difficult to just kind of recreate something to a level where a judge will feel confident that it's fair and accurate, or at least the jury is told it's not an exact replica, but just to give you a sense of what's going on. I mean, probably not. I mean, I would want, if you're going to do that, to me, the big one would be the truck, the plow truck, the Frankenstein or whatever they call it, to really show how far out that beam of light goes. I don't know why you couldn't maybe have a picture of that plow or truck, whatever it is, right in front of the house
Sign, I think.
at
Yeah.
night, and just turn the lights on and put it where the plow would be positioned, and then say, this is what you can see. Now, again, that may or may not be helpful, because it depends on what the witnesses are even saying in terms of, did I look? I mean, it may very well be that the jury could find, well, the yard was lit up and nobody was looking. So, I mean, what does that prove? But if the argument is that it was too dark to see, that could certainly be disabused by having it lit up like that.
Question came in. This is a good one. And probably, like you said earlier, probably the best thing that Brett did is play a video. How does the defense rebut video clips with no witness?
Well, if you're the prosecution, you're hoping you smoke Karen out of her cave and do it on the witness stand. That's one way to do it. That's not the way you want to do it. It's not the way I would do it, obviously, but that's the easy way to do it. I'm going to assume that these videos are being offered by stipulation, that the defense is stipulating to their accuracy, so that they are not there is nothing to cross-examine. Now, if they think the videos were unfairly cut or edited, or there's more to shed light on the nature of the conversation, there is a rule of completeness. I mean, if there is more to the statement that they cut off today that would put it in context, then the defense would have a right to play the rest of that section of a video to put fair context. But I imagine there's no witness because the defense agreed.
There was an arrest today in the buffer zone.
Okay.
All caught on video. This
Really?
gentleman was live streaming, doing a video chat or something. Well, state police were approaching him, and he's like, "Where am I supposed to go? I'm new here." And next thing you know, they arrested him. Just to me, it's crazy. Like this poor kid. He doesn't seem like he's very well off either. Apparently, some people saying they put a mental health hold on this gentleman. I mean, what do you think about that, Mark? That they're arresting people in the buffer zone just for holding up a video camera or a phone?
I think arresting people in the buffer zone without, warning them and doing that kind of thing would be what you'd expect out of stormtroopers and, other parts of the world at a different time. That's unfortunate. On the other hand, whether you agree with the buffer zone or not, it's there. I don't know what the guy really did or not. But just arresting a guy for kind of creeping around and doesn't know any better, I mean, to me, that's not what I expected to see.
That's him. That's him. Free bail. They've already memed him into a doll. This is him too being arrested, and
I mean, look, I don't want to judge appearances, but he looks like he's had a rough day or more, perhaps. I don't know what his mental health issues or substance issues are or not, but just arresting people. I mean, look, in all fairness, I don't know what led to the arrest. I don't know what he did. I don't know what they claim he said, but you'd like to think that there's a way to handle it if it's not getting threatening, or, you don't give 5 different warnings before you just start arresting anything. I mean, if he's doing nothing and he's just purely in the buffer zone and they just arrest him because they can, that's disgraceful.
And I did watch the video. That's pretty much what happened. I mean, the guy is just basically saying, "Hey, where am I supposed to go? I'm new here." He's playing dumb. I think he is playing dumb just to get some video. But I mean, some of the cops are actually like talking to him nicely and being like, "You got to go this way." You can tell they're getting a little aggravated because I think they know he's playing dumb. And then it looks like a more aggressive cop comes in and just gets aggressive. Yeah.
I don't know. I wasn't really familiar with this, but if they're you just shoo them along unless there's another reason to do it. And I don't really know what happened. I mean, obviously homeless is not a reason to arrest them.
And I'm using homeless from Aiden. Aiden called him homeless. I'm assuming he is. I mean, he's definitely not well off. There was video of him in the past with KP, but this guy, like Aiden said, seems harmless. He seems like he's not a. I know people who know about this guy, and they say he's not like a troublemaker.
Is he a local or what is he? I don't know anything about this. Is he like a trial watcher who travels?
Yeah. I think a lot of these folks, they get their little YouTube thing going, and everyone wants attention, right?
Well, he got it. I mean, his picture here, and we're talking about him. I'm not sure that's the kind of attention you want, but I mean, look, the buffer zone itself is. There have been plenty of cases, believe it or not, that have been bigger than this that did not require shutting down city blocks to prevent people from saying whatever they want to say or doing whatever they want to do, as long as it's lawful. So to me, the whole buffer zone thing is kind of silly. I'll leave it to others to decide whether it's unconstitutional. I know they're arguing, or they did argue, but I mean, arresting people for just hanging out in front of a courthouse, doing whatever. I mean, that's your tax dollar. I mean, you're gonna have to pay now to house this guy, to feed this guy. If he goes to court, you're paying for all that. And the question becomes, where do you come out on the tax dollars for this kind of shit? Some people might say do it. That's fine. But, if he's just kind of a local bum with a camera, I don't know what the point of that is.
Bad for the guy. I do. Because I could tell he didn't have any idea they were going to arrest him. Like, he just, he's not, to me, watching him, he does not seem like someone who's being aggressive or overstepping boundaries or any of that stuff. It just seemed like he was, playing a little dumb. Wanted to see what the line was, and he found out. And, I think he's going to win if they actually charge him. Joe Flipperhead's here. He did a Mazda the other night. He went on I don't know whose show it was. Whose show was that? Oh, it was Auntie Deb's show.
I saw.
And he revealed himself. He put his face out there. He's got a bunch of women now swooning over him. He says, "What's Bunk think about Telly still prepping witnesses? Wasn't he moved out of North Fork County District Attorney office?
So
feels so wrong." And I also, before you answer, I want to know, what do you think about Flipperhead? Is he live up to the hype when you saw his face, Mark? Because he's given you a lot of shit over the months.
Well, I don't judge his appearance, although he's a fine looking man. But no, he's great. He's funny. He's witty. He makes funny videos. A lot of pop culture references. I mean, can't say much about his preference for sports teams. They're mostly, shit selections, other than I guess you have to give him the Eagles because they won the Super Bowl. But no, he's good. He's good at this. Good cultural references, funny, witty, and I would say first-rate analyst too on the case in terms of breaking down problems and things and analysis. So it's good, very good. But as far as Tully, he was moved out of the office. I think at the time they relocated him elsewhere, probably to the Framingham headquarters, I would imagine, right? Used to drive by that every day on Route 9 there. But I think they even said he will continue to work on his old cases, whatever. So I don't think it's a problem in the sense of he's creeping around his job. The bigger problem is, why do you want this guy prepping witnesses? Because he's Tully and he's in the soup in multiple cases for all kinds of things. I just don't know that if I'm the prosecution, that if I want to interview a witness, he's the guy I want to bring with me from the state police. You know, Brennan, that's what he did. He brought him, not Lally, apparently. I would have just brought somebody else who is there to be a witness, so that if I'm Brennan, the lawyer, I don't make myself a witness. But I don't need Tully to do that. I mean, I don't need Tully to tell him, I remember I interviewed you before, whatever. I mean, I don't, it's not a move I would make. I think if I'm analyzing this case from the DA's perspective, they don't think there's anything wrong with Tully. That's fine. But the defense has a very different view of him. And I just think you're potentially feeding that monster a little bit. It's not the biggest deal in the world, but I would have used someone else.
Somebody else, Proctor. Question about Proctor for Joy. Joy says, do you think Proctor will come clean with everything now? Not necessarily in court, but to the feds, he has nothing else to lose.
Well, he has a lot to lose. Number one, he'd be admitting that he perjured himself at the first trial, for starters. Number two, I think he has some kind of delusional belief that he perhaps maybe will get his job back. That's not going to happen, I don't believe. But, he has a right to pursue that. Even he has constitutional rights and, other rights. And also, look what he would be doing to his family. Okay. He didn't come out and defend himself. He sent the women out. He sent the wife and the sister out to make these, very aggressive statements and all of this and all of that. And if he came clean now, then he would have just punked them and embarrassed them, and clearly would have been lying to them, which I don't think that's something he'd want to do. So at this point, no, I think he's disgraced. He's terminated. His career is over. He has no credibility. It's now come to the point where he's a punching bag in an opening statement at a trial, being called a metastasizing cancer. I mean, that's a pretty low point in your life, I think, if somebody calls you that. But whether he thinks that's fair or unfair, at this point, no, he's going to deny it, whether he should be or shouldn't be. And I think hopefully, from his sense, he just hopes he fades away and loses attention.
Hope so. Got a couple more. Here's one that I want to ask. Nope, actually, that's not it. Hold on. What do you think about this one? CJ says, why the difference in the depth of the snow between Kerry's dash cam and the photos of them cleaning off the snow with a leaf blower?
Well, I mean, if we're talking about Kerry, I mean, she didn't have a dash cam. I think she was just describing what she kind of made it sound like it was a huge snowbank. And I guess the inference is, how could Karen know he was there if there was a big snowbank? I don't think that's an accurate assessment of what was there at that point, but I don't know. But why the difference in depth? I don't know. I mean, there's a lot of issues with the snow, which I think will become very important in this case. On the one hand, everyone's inclined to laugh about the leaf blower. When you first hear the leaf blower, you sit there and say, wow, that's just awful. But then when you heard the testimony the first time, and presumably it'll be the same the second time about the leaf blower, reevaluate that. The guy said, was it Gallagher? Gallagher. the area where they used the leaf blower is where they were told John O'Keefe was, and there was blood there and like a broken piece of glass. So logic stands to reason. Yeah, that's a good location to believe where he must have been. So let's clear the snow and look for whatever. And my recollection of the testimony is that they claimed that they were able to get down to the grass. Okay. Like that the snow at that point was fluffy and easily moved. And I believe they claimed that they cleared a something like a 7 by 7 foot area and found nothing down to the glass. But the later searches, right where he was found, they found what they found. Now you know what the DA is going to say after you heard their opening today. Well, the reason why they found part of a drinking glass there and no taillight glass there is because John O'Keefe was wandering for 20 seconds in no man's land, and then just fell. Which, by the way, if you believe that,
Zombie. Yeah.
now you're taking away any claim that he smashed his head on the curb. And now they're going with he just split his head open on, hard as a rock, whatever the hell that means, ground. And, the defense expert you heard, again, openings matter. It's not evidence, but they plan it in your mind. The jury knows that there's going to be a defense expert who's going to say that head trauma, the back of the head trauma, can't come from smashing the ground on a flat surface, that it's either like a ridge or an angle or something. And the only other angle in that direct area, because again they said he wandered there, so it can't be he just fell. So what are they going to say, that he smashed his head on the fire hydrant and then just meandered over there? None of this. I just, when you think about it, doesn't seem to make a hell of a lot of sense. So to me, the leaf blower, although it sounds silly, it's actually a favorable fact for the defense, in my view, for the leaf blower story to be maybe not great police work, but doing what they did, it did show you that where he was found, there was nothing there. And later, when the CERT team does their search and does, which is the wrong search team, by the way, and that's another Tully thing. That's why he's got issues. He's got a lot of issues as it relates to that search, by the way, a lot. And I'm sure that'll be a big deal. But they presumably would have covered that same area. And now they're finding piece here, piece there. And, it doesn't make a lot of sense.
A good question here from Annie. Annie says, any chance you think Proctor will say I handed over the Sally Port videos to Lally when I got them, if that is what happened anyways? And I'll just add to that too, like, I feel like more than like going to the feds, he might push back on the stand in terms of the hits he's taken on his character from everybody else. Like, everybody's blaming Proctor now. I just wonder if he might stand up for himself more on the stand and push back on some of the stuff that he actually didn't do that he's now being blamed for.
It is.
What do you think about all that, Mark?
It is human nature to defend yourself. And he wasn't asked about this issue at the first trial. So there's nothing for him to perjury by inconsistent statement himself if he were to take that position. No one talked about this narrow issue at the first trial. I don't know what the truth is. I've always found it extraordinarily hard to believe that the two prosecutors, one of whom was there today, one of whom was not, that the two prosecutors from the first case with a straight face were supposed to believe for the better part of 2 years in an investigation and prosecution like this, literally had no idea about any of this evidence's existence, about the existence of cameras in the Sally Port at all, about where they were. I find that hard to believe. But having said that, they clearly made Proctor the useful idiot for their non-legal defense. That was a personal defense of their integrity by the prosecutors in those motion papers, because that was legally insignificant. It was in their possession, legally speaking. So does he push back on being a patsy or a useful idiot and say that's not true? If the DA has any inkling that that's what he's going to do, that answers the question from earlier about whether he's testifying as a DA witness. That would be a no. But
when you'd pull him off.
I don't know what he's going to say. I'm just going to assume that if he does testify, that he probably sheepishly plays the role of useful idiot and just kind of gives you that hound dog look like he did with the text messages and says, you know, I pulled the video and I just forgot and it really didn't occur to me and there's nothing to it and whatever. I mean, I don't think he's going to literally go after them. I don't see it.
Mr. Monk's understudy says, what's going on with the Kevin Albert motion?
What is the Kevin Albert motion?
I'm not sure. That's a good question.
I don't know it. I'm not.
Tell us what it is, Mr. Monk's understudy.
Is that about his disciplinary history or about whether they're going to be allowed to get into him, drunken,
losing his gun or whatever,
partying with Proctor and losing his gun and badge?
I guess Chris Albert says he didn't actually lose his gun or something now.
Well, how does he know? Because Kevin Albert told him? I mean,
I don't know. Yeah. So it says it's a new motion, new filings today. So
I haven't seen it, so I know nothing about it.
Yeah, we don't know enough. We don't know enough. It's hard to keep up with everything when you're watching it online, and then you have a show that night, and just
Yeah.
Then the filing stuff during the day. Just reading the comments, seeing if we're getting any more info on that. But Katie says, will the defense use John's voicemail where you can hear Jen calling her sister saying someone is coming to help? You can reference the Microdonts video.
I think so. I mean, I think that's certainly something I would do. I don't know what kind of answer you're going to get. And I don't know that she's not going to argue with you about, I didn't say that, no one answered it. I've heard the videos where you can apparently hear her whispering. It's on the back of the 911 call or whatever that, or the voicemail that just picks up this conversation. But certainly there are records of that call. Why is she calling Nicole at that time? I know, if I recall correctly, she might have even called her earlier that night when they were still elsewhere. And then she just walked into the house, doors unlocked. And according to the witnesses who lived there, she was screaming like a banshee, waking up the dead. Whereas 2 minutes earlier outside, she had no affect at all about what was happening, whether on the 911 call, whatever you see on the dash camera. So that whole scene is going to be very interesting to see what they do with it. But I would imagine that they would have some pretty tough questions for Jen McCabe about why you were calling Nicole and what was being said. And when she denies that there was a connected call, why were you calling her in the first instance?
I have two questions about these text messages. Quack Quack says, Mark, why does the state get the defense text messages from their experts? And there's also another one related about text too. They want to know, was Bev correct telling the defense today about preserving text from 2 years ago?
I don't know. I mean, it depends. If there's a text message between one of the lawyers and one of the witnesses, and it says, are you available for a conference call at 9 o'clock? And he says, I'm good at 9:30. See you then. Da 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 da. And the next thing you know, there's 27 text messages about nothing. You know how it is. You go back and forth. Are those discoverable? Maybe. Are they relevant? No. I mean, if there are statements of witnesses that relate to the subject matter, they absolutely can be discoverable the same way, you go after conversations with the prosecutor and prosecution witnesses. But if they don't exist, which is what they're saying, there's nothing to disclose. They don't exist. And as Alessi was saying, if you want to go at them and cross-examine them and accuse them of all kinds of stuff, and, the ARCA doctors, they're deleting messages and helping cover up because they're biased and part of a conspiracy to screw the Norfolk DA, have at it. I mean, that's just silly and won't be effective. But, you are supposed to preserve client files and evidence for, I think it's like 7 years, whatever it is. But does a text message on a phone, the kind of thing that would necessarily stick out to you, is something that would stay in your file if it's about nothing? Or if it's about, did you watch The Handmaid's Tale last night? What'd you think? I mean, whatever. I mean, the irony is seeing this on the other foot, because the defense has been asking for stuff and the prosecution is like, doesn't exist. And the defense says, well, we need to know that metadata could show something. It doesn't exist. So there's nothing to show you. So don't worry about it. When the shoe's on the other foot, there's all this righteous indignation to the point where they filed a motion today saying we should adjourn the trial 2 months because we don't have all this important information, and we're also missing some text messages. So there's no reason for this ARCA thing. I know we talked about this before. There's no reason for it to just stop the trial or be an issue and have a hearing on Friday. I mean, it's just, what a waste. But that's what happens here.
Norfolk County, wasted time and money.
Yeah.
Darcy has a question. If they had a case, they wouldn't be doing all the extra nonsense.
Well, this is what we talked about last week, which is, if your expert opinion is airtight and it's bulletproof, then your guys have already told you, presumably, why the ARCA guys are wrong. And if you're spending all this time whining and complaining about, I need to know now, I literally can't continue the trial without knowing what they're going to say about my expert, well, that probably tells you a lot about their confidence in their own expert. And of course, there's all kinds of psychological warfare and gamesmanship going on here, where you heard Bob say today, our experts can't even look at this stuff. Like, this does nothing, which is their way of saying, these guys don't know what the hell they're talking about anyway. So, what are we supposed to do with this? Listen, ARCA, I mean, I'm not a scientist. I'm not into that kind of stuff. But when you are working for the federal government on national security issues, designing material for the U.S. military, you are working on safety standards for the National Hockey League and doing all these kinds of things, and you end up being presumably the first choice to get hired by the Justice Department on a very interesting investigation, you're top of your field, okay? There's a reason why they get hired. And you saw those two guys, their demeanor, the way they testified, their confidence, their likability. You can tell, though, they're not familiar with how a court proceeding works, because they're just scientists, right, to some level. And the idea that Brennan is going to get all snarky with them and all pissy about the $20,000 and how you're in the tank for Karen Reed because you became a witness 3 or 4 months after you rendered an opinion about a case you knew nothing about, just strikes me as a clown show. I'm still not even convinced they're going to do this, that this isn't all just sticking their chest out to look tough and try to get them kicked out. But when push comes to shove, that an experienced lawyer like Brennan understands that ARCA getting $20,000 because they sent the bill after the trial to the lawyers and they paid it, which is, by the way, the right thing to do, that somehow makes them biased for what they found 3 months, 4 months earlier. That's just stupid. I mean, that literally is going to make you look like you're over trying the case and that you're terrified of these people. The way that the prosecution should handle ARCA is to say, our toes are tapping. They're wrong because our guy, Welcher, or whatever his name is from Aperture, he's going to have it right. But instead, all you're hearing from the prosecution is these guys are hired gun hacks. We're not getting disclosed messages. They're part of the corruption with the feds in the defense. And not only that, we need to know what they're going to say about my witness because I can't prepare. That's not a position of strength. That is a position of weakness. They are coming from, I mean, don't look at what they're saying. Look what they're trying to do. Look how on one hand, it's always like, we're not trying to exclude ARCA, but on the other hand, they're always trying to exclude ARCA. Look, I mean, they're giving themselves away. They're terrified of what these guys are going to say. And they're terrified that unlike the first trial, it's not really a fire drill where they just get them and they have to throw them up on the stand cold. They're going to be a little more prepared. And yes, they're going to look at the Aperture report and presumably are going to tell the jury why, in their opinion, they're wrong. And Brennan is not dumb. He may be many things. Dumb is not one of them. He recognizes that in a battle of experts like this, it can't be a draw. It can't be probably I like their experts better. I like the Aperture guys in the jury's eyes more than the ARCA guys. The Aperture guys have to destroy and kneecap the ARCA guys to the point where a jury says they're not credible, not because they're liars or corrupt, but because they're not great scientists. They're not going to discredit them because they got paid $20,000 after the trial or ate lunch across the street during trial when they're defense witnesses. They're not going. That's not how you're going to discredit them. The only way to discredit a witness like that is that they're wrong on the science. And
it's like Trooper Paul. He was bad at the science. He looked bad.
But they're more concerned about what the ARCA guys are going to say about us than being confident in their own guys.
Right. It's weird because I obviously they know ARCA is the slam dunk. I mean, these guys know their science. They look good. They get the facts behind them.
Yeah, and again, there's another difference here, and this is also part of the irony where Brennan wants to have, a production about a $20,000 payment. Okay, these guys were not hired by the defense or anyone associated. That's a fact. Okay, he can bitch and moan all he wants. It's just the reality is you don't like it, okay, but the Justice Department hired them. Okay, the U.S. Attorney hired them. Too bad for you. If you're going to make a stink that they're bought witnesses and so they're biased for $20,000, well, how much money do you think Welcher and his firm is getting? And that's coming straight from them to be literally a hired witness. So, you really want to have that battle, have that argument, because the reality is the defense is going to elicit about them on cross that when were you hired? And what are they going to say? Like, I don't know, late 2024, right? And the ARCA guys are going to say, I was hired in February of 2024, and we were hired by an unnamed, an agency,
independent,
shall remain nameless kind of thing. And what is the other firm going to say? Were they hired the same way that a lot of the other experts were hired? Where Tully put out an RFP looking for experts. Well, that's what he did, right? For the cell phone guys. I mean, Tully was sending random emails, cold calling.
LinkedIn. He's looking on LinkedIn.
Yeah. I remember I was there when last year when Jessica Hyde was testifying, and it's not her fault. She got business. Good for her.
She needed some money. She got her rent paid.
Yeah. But that's what you do. You're in this, you get hired. But I think her testimony was, I just got in my, info at Jessica Hyde email box, hi, I'm Sergeant Tully. Can we hire you? And then they gave her a very narrow task. They didn't even let her look at everything. So I don't know why they think they're going to accomplish anything going down this path by attacking the ARCA guys as these hired guns for sale who are bent on screwing the Norfolk DA's office. It's stupid.
It's funny because this is the pattern here. This is the next question here from It's Never a Mannequin. We've noted it tonight. We've noted it over and over again, but we'll bring it up again. Can defense call out Bev about penalizing them for discovery violations when prosecution is still sending discovery after the certificate of completion?
Sure, they can. They can say whatever they want. I don't know if they're going to get the reaction they want, but they have a right to make a record on anything. Um, they haven't done that yet. They've never pushed back like tit for tat with this kind of stuff. They've focused on the merits of the current argument and defended themselves. And, they ought to be credited for that. They're not turning it into, well, he did it, so why is this a big deal? That's not like the most strong lawyer argument, right? But they can say whatever they want, and then they just have to live with whatever the judge's response is.
Yeah, I mean, this is the problem with the whole thing, and this is the next question too. Maybe the final question here. Not so special prosecutor Breenan. Says Mark, is there anything the defense can do about the way the judge speaks to them? Like telling them to wrap it up in front of the jury, making them cut off their questions, arguments short, but not the Commonwealth.
It's a problem in this case. It's always been a problem in this case. And you have to pick your battles and know when to do it. And it's very noticeable. But you also saw it today when she tried to shut down the video, and Alan said, I have to do this. This is like important. And, she kind of backed down. Well, I'll give you a couple minutes or whatever it was. Maybe it was the wrap it up comment or about like there's more to go. Look, you have a judge who clearly doesn't like the defense. I mean, that's just, but by the way, that's not that uncommon. It does feel a little more personal this time than in other cases. I think a lot of her rulings about the ethical violations to me make no sense at all in terms of suggesting that they have deliberately and intentionally suppressed evidence and lied about it. I mean, I think that's patently unfair and can be very harmful to them without any basis. But, what can they do other than say, we think you're being unfair and this is bullshit? And, I don't think they're going to do that. Might they try to say something privately? When I say privately, I mean in the presence of the prosecutor, not ex parte, but like not in front of the jury about, we're very concerned when you say wrap it up. They could. Another thing that she does, which I think is very improper in my view, is when you get these objections, rather than make a ruling, she asks the witness, she defers to the witness, can you answer this? And leaves it to the witness to resolve the legal argument over whether an objection should be sustained or overruled. That's crazy. Moreover, when you have an objection and a judge looks at the witness and says, can you answer this? That's a lifeline to say no. I mean, that's giving you that's giving you an out. That's something I might also kind of gently say, I don't think you should do that. And she'll say whatever she wants to do. But she's done that a lot in the first trial too. And I think, asking a witness like Nuttall, can you answer this, is not an appropriate response to a legal objection. That's not an answer. An objection is a legal basis to say this question is improper. You don't resolve that by asking the witness, what's your view on it? I mean, if it's an improper question, it's leading, there's no basis. It assumes facts, not in evidence. It's hearsay. Those are legal determinations, not, firefighter Nuttall. Can you answer that? And no. I mean, that's just
put some cream and sugar in there. I mean,
it's passing the buck.
It's weird. It's
not appropriate. The witnesses don't get to decide a legal answer to an objection. So that there's all kinds of things that are happening here that I don't think
strange.
Proper. Yeah. I don't think the jury selection in this case was proper. It doesn't mean it's a bad jury, but but it's, a judge is the king or queen of his or her domain, and that's the way it is. And as lawyers, you just deal with it. You may not like it, but you're not going to sit there and sulk about it and let it get in your head. I mean, they know what they're dealing with. It's not new. She can be a tough judge, and that's just what you're dealing with. I mean, you just have to deal with it.
Oduck Citizen doesn't really have a question, but a great comment that I wanted to bring up. Said Brennan said Karen Reed said I hit him, then said that didn't mean anything to the EMT because her statement didn't reconcile with the evidence. He's admitting the evidence didn't match a car hit.
I heard that. I know exactly what you're talking about. I don't know if he misspoke, because in context, I don't know that that's what he meant. It's what he literally said, but that's also part of the risk when you you want to impress the jury by walking around and, I have this memorized, which can be very effective, but usually that's more effective when you also are passionate, and you do what Alan does. You go up, you go down, you pregnant pause, you do this. If you do that while you're looking at the jurors and you're going from here to over there, that can be very powerful, right? But when you're just kind of going up and down the jury box in the same monotone, stale manner of presentation, I don't know how effective it is. But the other risk is, you may misspeak. He did say, I think, that the Nuttall statement would be on video, and it wasn't. That's just not right. He said that John O'Keefe was from Canton. He's not. Not that that's a big deal, by the way. That's not an important thing. But I mean, how do you get that wrong, right? I mean, they're all. I mean, his familiarity with all the facts isn't what you would expect. But I mean, don't mistake that for not being prepared. He's obviously prepared. I mean, he obviously was prepared to give the opening. He's very intelligent. I mean, his style doesn't do much for me, but people should not assume he's not a good lawyer because he may have misspoke something. I think the jury understood what he meant, and I don't think he lost ground by saying, it doesn't reconcile. That can't be what he meant to do.
Do you think there's any chance that he's intimidated by Jackson, like in terms of the skill level mismatch, or do you think he feels fine in there?
No, I think he feels fine. But I also think, I think he's a little outclassed in the sense that Alan is a much better speaker. He's a much more charismatic advocate. He's, from out of town. So there's always going to be, maybe people don't like that. Brennan's a local guy. I mean, that's for damn sure. You hear him talk. He's, it's a thick accent for people from there, obviously. But no, I don't think he's intimidated. I mean, he's a good lawyer and he's a good litigator. Again, his style is not for everyone, but that doesn't mean he's not a skilled lawyer. He is. I mean, it is an upgrade for the prosecution to go from Lally to him. It doesn't mean he's going to win. I don't think he is. It doesn't mean I think his opening was that good. I don't. But I think the prosecution team is better than it was by a lot than the first trial. But what's interesting is he's doing it alone. I don't know why these other people are even at the prosecution table. I mean, Lally's staring at the wall right in front of the jury. And if that's what it's going to be, I would almost tell him, like, go home.
A question about expert witnesses. What do they usually get paid, Mark? It's usually like what, 50 grand or something like that, or even more?
Some of them are hourly, some are flat fee, and witnesses can get paid at different rates. I mean, you hire a private investigator, they're going to bill you, a couple $100 an hour or something like that. You hire scientists for Marco, they may tell you point blank, I need a retainer of $150,000, $250,000, $500,000. I don't know. I mean, obviously, the higher up the chain of credentials, it costs more. So, the ARCA guys are going to be in the high end of the scale. Medical doctors could be up there as well. They're not going to charge as much as ARCA, but they're going to bill for their time. It's going to be a high hourly rate. whereas some experts may cost, literally a couple $100 an hour, less than $5,000. It totally varies.
Right. It's been I think over 2 hours now. I keep saying the last question, but I want to Aiden Carney, Turtle Boy, any updates on his case lately, or is things pretty much the same since the last time we talked to you?
Well, he's in the courtroom. He's covering the case, so that's good. We are still awaiting a decision on a motion to dismiss, which I think was argued maybe 7 weeks ago. So that's a fair amount of time. But beyond that, we're in the waiting game, as they say. We're just in that kind of purgatory of a criminal case. There'll be some motion practice coming up soon, and some other stuff that people may find interesting, but nothing to discuss publicly or anything like that right now.
Correct. And anything else that you wanted to bring up from today that wasn't asked or we didn't bring up yet? Anything even looking forward to this retrial?
I mean, who wants to see this again? We already saw it once. I don't know that anyone's looking forward in that sense. No, to me, the thing that I would be looking forward to seeing were, one, did the prosecution have something dramatic that they've been holding back? You heard about all these chip offs and all these other scientific tests and all these things that people were talking about, and you didn't see it today. What you saw in that regard was they apparently are trying to fix a time of 12:31 as the triggering event or whatever we're calling it. You saw a reference to, they think the cell phone temperature is important, but they have some videos that didn't exist for the first trial. But that's really it. You don't have, at least in terms of their opening, and there'd be no reason not to open on what you have. You didn't hear anything. But from the defense side, the changes are much more dramatic. You have Proctor is now terminated for bias, amongst other reasons, against this, as he said, this defendant. You have medical examiners who are going to give favorable evidence to the defense. That's very important. They're going to have evidence that the phone was used after the alleged accident, which is very powerful. Evidence that there was no frostbite or hemothermia, that can be very powerful and helpful for them. So, I mean, to me, not always, but in this case, the retrial was going to favor them, and they have a chance to fully evaluate what all these witnesses said. I mean, they can't change their stories, right? They can get these new scientific witnesses, but what are they going to establish? You also know this time around, the defense is going to introduce evidence that Jennifer McCabe deleted, or somebody deleted, one text message out of over 4,500. That's not good. You clearly heard reference to, they're going to use the waterfall video, not so much to show the Bryans grabbing ass, but maybe Brian Higgins looking pretty upset right around the time that he was, having words with Karen and John O'Keefe. So, I mean, I think there's just a lot of stuff that they're doing differently.
It's going to be interesting too, because you got Chris Albert there holding back Higgins, so it's like we're going to be. I think.
Well,
the defense is going to be asking Higgins.
I think they're going to
Albert. Yeah.
I think with Chris Albert, part of the questioning becomes, is that why he went home?
Yeah.
Did he know something bad?
Yeah.
Was going down.
What were you saying to him there? What were you saying in that moment to him when you're going to kind of hold them back, and would you tell him to cool off? You know what I mean? Like, would you?
Well,
chill out.
He's going to say, I don't remember, right?
Yeah.
There's nothing. And I think Higgins testified at the first trial. Everyone was having a good time. Everyone just left. But he's pointing, and, again, is that proof that he did anything? No. But now you have the video of him making phone calls at 1:30 in the morning that they didn't know about. I mean, there's so much.
Butt dials. I'm glad they brought the butt dials up right at the beginning too. That was like a really good opening today.
Yeah, well, the butt dials, that's like a real problem for the prosecution, because one butt dial, you would say the odds of that happening are probably, less than 1 in 1,000. But the odds of Brian Albert butt dialing Brian Higgins, who doesn't answer, but yet Brian Higgins just gratuitously butt dials him back a minute later for 22 seconds, the odds of that, I would say, are probably less than one in, a few billion. Then you add the fact that, Jennifer McCabe is already on record saying, I must have butt dialed 6, 7, or 8 times. At the same time, I'm looking out the window and texting John O'Keefe. I mean, put all this together, and the argument, again, in a reasonable doubt context, is to believe all of this, you have to, it's like paranormal, suspend reality, like he kind of said. But the larger point on that is, this is all suspicious behavior about people who ostensibly have no reason to be engaged in anything suspicious. And they're going to have to deal with that. And then, it is right in time around the Google search. They claim you do know that was deleted. You go on and on with this stuff. You have that family text message chain about, they're digging at the Asian house.
Yeah.
Telling me when in the house. They're at D&E. She's telling them everything. Right?
Carrie. Yeah, Carrie's telling him everything.
Don't want to talk about this on text, Nicole Albert. Why? Your friend unfortunately died by getting hit by this psycho, kind of, sort of, but not really friend of yours, that unfortunately ended up on your front lawn. That's unfortunate. But you did nothing wrong. Like, you're not involved in this. It's just, it happens to be at your house. What the hell is the reason for all of these people texting like kids all day and then saying, kill it, take it off text, don't want to talk about it later, like, not for text? What's not for text about the fact that, like, I can't believe our friend, I can't believe she did this. This is, now, it doesn't prove they did anything wrong, but it's suspicious. It's not natural. And there are so many occurrences of that happen that they're going to have to deal with. And, he didn't come out of the house. They sold the house, the dog. You could go on and on and on with all of this stuff, and they have no burden of proof. So, unless there's some smoking gun that we're all unaware of, I just don't see how they get past that. I never have understood, but I think now, with the more you learn and the new evidence that the defense has previewed this time, what are they going to do?
Seems like it's going to be better for the defense this time, even better.
I think so. I mean, you have to wait and see how it plays out.
Early, it's so early, but just from just looking at the early results, it looks good. I mean,
yeah, no, I mean, I think the defense opening was better, both in terms of knowing what you have to accomplish, whatever the burden that you have or the other party has. And I think the delivery was much more engaging, just in terms of manner of delivery. It's more compelling. I think it's more captivating, as opposed to a story about firefighter Nuttall's call to duty. I just don't understand that as your opening salvo at all.
one more great question that came in from Debbie Salmon. He says, nothing about the letter you sent Morrissey. Did you ever get a response from Morrissey on the letter you sent him about Chris Albert?
We're not talking about letters tonight, but letters serve a purpose. That's all people need to know. And sometimes they can function in different ways and serve different purposes and lead to other things and whatnot. And, the Twitter lawyers can probably explain what that means. But, tonight is not the night to talk about what's going on with letters and other things. But, stick around.
So funny, because someone commented earlier about they didn't think I understood about when you make the comments on the Twitter lawyers. There it is. Be our last one tonight. Nita says, Mike, you are misunderstanding what a Twitter lawyer is. It is definitely not a real attorney, Mark Bederow. What Mark was explaining to you is that they are idiots who have no real law knowledge. Yes, that's the point to me. That's my point. That because he is actually a real attorney on Twitter. Those other people aren't real attorneys. They're just on Twitter. Go ahead. Mark, you want to say something about it?
No, I mean, it's funny. I mean,
It is.
Twitter is an interesting place, and everyone has a gotcha for everyone, and some of these people are just so biased and so interested that they will say anything if they think it's a gotcha moment. And a lot of times when they delve into legal analysis, it's comical. And I mean, there was some of that last night actually about the Massachusetts witness intimidation statute, that you just look and you just, the expression, like, you can't fix stupid. You just, at some point, you just have to throw your hands up and say, whatever. That's Twitter.
It is Twitter, especially with those Twitter lawyers.
Yeah, a lot of Twitter lawyers. Yeah, everyone's an expert.
Notice too, they're always on there too, some of them, because they don't do any work. Like, this is being a full-time Twitter lawyer. It's really demanding.
Yeah, no, it's not healthy. It's definitely not healthy. If most of your human interaction is on a computer, it's probably not healthy.
I keep saying one more last one, but our audience just keeps throwing up good stuff. So, P.S.
St. Croix.
This is one say I gotta get my glasses on. P.S. St. Croix. I can't even say it. St. Croix. St. Croix.
St. Croix.
Yes, Croix says, can we now confirm Wendy was wrong again? Was Wendy wrong again?
What did she do now?
I don't know.
It's hard to keep track. I mean, the default answer is, if she says it,
it's always wrong.
Right. But I mean, I don't even know at this point. Are we still talking about her Fifth Amendment analysis? Are we talking about throwing cocktail glasses at cars? I mean, I don't know.
Pirouette. Yeah, the pirouette.
I mean, she's probably wrong. I don't even know what you're talking about. I'm just going to.
Yeah, we don't even know, but we know she's wrong.
Yeah.
We've known she's been wrong since Duke Lacrosse.
Yeah.
Remember that, Mark, when we were looking all up that stuff, and we were like, look at this, look at this.
Yeah, well, I mean, it was only fascinating because, anyone who's familiar with criminal cases and prosecutorial misconduct, Duke Lacrosse is the poster child for improper prosecutorial behavior, overzealousness, suppressing favorable evidence, obsessed with media to the point of prejudicing a defendant's right to a fair trial. And one would not assume that a former prosecutor and self-styled civil rights expert would actually back the DA in that case, who went to jail. I mean, the district attorney in North Carolina, actually, Mike Nifong, went to jail as a result of his conduct in the Duke Lacrosse case, and that was not dissuading at all. The fact that the alleged victim in that case was not a victim at all was so discredited. I think her position on that was, no, she just got paid off. They paid her off to be quiet, and then when she finally recanted, they paid her off for that too. Left unanswered is any comment on why she went to prison for murder. That's apparently a different issue that doesn't warrant a discussion of her credibility. No legal analyst should ever be taken seriously ever again if they still cling to that. And that's why, I mean, all kidding aside, with how crazy she is, I can't believe that anyone would put her on, because that's just so discrediting. I mean, that's so awful. She's not serious. That's the bottom line. She's not serious.
Question, Mark, new Kowloon or old beloved Kowloon? Your opinion?
I mean, it's different, right, from the old days. But I mean, I'm it's Kowloon, so I'm not complaining.
It's always good.
The wings are
still
still
good over there.
Everything's still good. Yeah.
They're asking about the China Pearl. I know where that one. Was that the Framingham one that you?
I don't think so. No, the Framingham one we used to go to was called Lotus Flower, but it's out of business now, unfortunately. A
No
couple of years
China
ago.
Pearl. How do I know? Is that the one downtown Boston? Maybe.
I don't know.
Getting confused. I've been to a lot of places. The thing is, I used to deliver beer. Yeah, that is downtown Boston.
China
That's right.
Pearl?
China Pearl Restaurant.
Well, that's
There's
good.
also one in Quincy. I
Okay.
thought there might be one on the North Shore, maybe. I don't know. Yeah, but the one I was thinking of is in Boston. That's like
Okay.
a downtown crossing area.
Okay. It's good to know.
Yeah. Everyone's throwing out all their favorite Chinese places in the chat. I want to thank you so much, Attorney Bederow, for being here. You have any other shows coming up this week?
Not that I'm aware of. No, no.
Well, we'll book you any night.
Well, not tomorrow. Tomorrow,
Yeah.
Celtics playoffs game without Jason Tatum. By the way, that's not good.
Is he hurt? What's up with that?
Wrist, so he's one game out, I guess. But yeah, so there are playoff games. I think Wednesday, Friday, Sunday. So certainly, anything Thursday is probably out because I'm going to be in the city all day Thursday, so that's not going to work. So whatever, we'll figure it out.
Figure it out. I'm thinking maybe even Sunday or Monday. No, we'll see.
We'll figure it out.
We'll figure it out. I want to thank you so much for being here. It's over 2 hours and very appreciative. Thank you. Your dogs have been good tonight. Have they been around, Lola and Winnie? I haven't even seen them
was
at all.
creeping around in the back earlier. I could see her in the screen maybe an hour ago. She was sticking her head out the window and walking around, but she's not here. So usually she's like right under my feet, but no, she's not under the desk. So they're doing their own thing tonight.
Someone says, "Do you remember Way Loose?" My grandfather used to take us there. The fried ice cream.
I know
Way Loose place. Do you ever go to that place? No.
I remember Foyloos. No, out where I lived, we used to have. There was like creameries out there, but I don't know where they were, and they were like farm looking. I work at Kowloon. There, wow, that's like the best comment all night.
Yeah, Tina. She works at Kowloon. We're gonna have to hook up with Tina next time we head over there.
Yeah.
Yeah, Way Loose was great too. That was the other place that a lot of pro athletes used to go to there on Route 1. I like them both, Kowloon and Way Loose. Way Loose, the best. I like the Way Loose because they had the fried ice cream. Their fried ice cream was so.
Yeah, I'm
good.
not big on fried ice cream. That's the crunchy ice cream is not. Yeah, that's not my thing.
We all got our things.
Yeah.
All right. Well, yeah,
all right.
Yeah, there was Way Loose up on the hill, and there was the Way Loose in the very beginning at the bottom of the hill. But again, thank you so much for being here, Mark Bederow. We start talking about Chinese food, we'll be here all night.
All right. Take care.
Have a good night.
Bye-bye.
Bye now. We're the Young Jerks. I want to thank Attorney Mark Bederow for being here. I really enjoy the time that he spends with us. He spends the hours with us, going through everything, answering all your questions one by one. It was amazing. I think most people got the message. There were some people that were trying to send questions through Super Chat. We're not doing the Super Chat questions for Mark Bederow. It gets out of control. We're just doing, if you have a question from now on, when he's on the show, just put it in the chat. If it doesn't get answered, just keep repeating it because eventually I'll see it. I know there's a lot of people and I don't get to see everything, but I'm looking for questions generally. So I want to thank Glenn Lake becoming a member today. He's one of the best supporters here. He gifted some more memberships of the streams earlier today. Thank you so much, Glenn. Brennan and Two Potted Plants, thank you so much for being here and making some great super chat comments today. Thank you, Dominic Harris. I also want to thank Steve-O24. And Strong Leg 1971 and Jen and a divine desire, excuse me. I gotta pull it full screen here. A desire for civil discourse. Thank you so much. Yeah, it does seem like that this is what the Commonwealth wants to do, is to punish Karen Reed, more costs, bring out ARCA. I agree with you 100% on that, actually. Seems like that's always their way here. Punish her financially. You guys are still doing so. I see the super chats coming in right now. PU, thank you so much. The lotus flower, huh? Mama She 13, thank you. And again, thank you so much, Debbie, tonight. It was a good question that you were asked earlier. Thank you, Mama She. Thank you, Sue. Suey Generous. And Strong Leg 1971, thank you. And some new members tonight as well. I want to thank you so much. And Pork Chop Express 355. And Red Tail, thank you so much as well. And Bloviating Brennan, David Reese, thank you. Lydia Halcrow, welcome to the Young Jerks membership. I think I got them all. TG. And one of the things I want to do on the way out tonight is we're going to play Brennan. We're going to play Brennan again. He was so good today. He was so strong. That's the best thing to end the show with tonight. Out of Asia was good. Yeah. Some good places in Cambridge. Oh my God. Nan Gallagher. Nan Gallagher just sent us $500 on the Venmo. Oh my God. Thank you, Nan. Thank you so much. You don't even know. Thank you, Nan Gallagher. Every time she does that, it makes me like blush. She just said $500. She said sponsorship. Thank you, Nan. Wow. I actually do need that too. You probably know why. We talked a while back. Laurie said $10. Kathy also said $25. She said, great show today. Free Karen Reed. Yeah, let me make sure that's it. 1 second. I'm not even on the. Oh, Laurie just sent $10 as well. I think I just said that when I said Kathy. I want to make sure I thank Beth. That was the other night. Beth sent $50 too. I think I did read that one the other night. Okay. I think we're good. Nan Gallagher, thank you so much. That just left me speechless. Wow. Yeah, that's fantastic. Thank you, Nan. Yeah, she is. She's the sugar mama. Gotta get Nan back on the show. She's a great guest too. Like the number one contributor, and then like one of the best guests that we could have on the show. Amazing. All right, let's close the show off. Let's play AJ today. And again, I got to pin to the super chat. We get this new domain, midnightmassnews.com. www.midnightmassnews.com. Make sure you check it out. Subscribe. It's pinned in the chat. And you might be able to tell I'm still like a little sniffly and I got the allergies. I did exactly what Mark told me to do. The last time we did that show, it was like the worst night ever. I barely made it through that show. This was much easier tonight. No sneezing. I'm feeling much better, but I still have it. You can still hear it. But we're going to close out the show tonight with Alan Jackson. Alan Jackson. His opening statement. Of course. I mean, makes the most sense, right? Stop the screen. Hold on. Let me add a screen. Second here. We all want to watch Alan Jackson again. I do. I want to watch it with the headphones right now.
Speed in the storm, in the darkness, knowing that he had just gotten out of.
We're going to turn it up a little bit.
The select board actually governs the police department, the Canton PD. He was there. His wife, Julie Albert, was there. Their daughter, Caitlin Albert, was there.
Hold on.
His sister-in-law. Catch any shit inside that house.
I think
the facts will show.
How do we skip
Now,
ahead? Here we go.
just a few more things I want to share with you. There are 3 charges against the defendant in this case. The first one, second-degree murder. When most people hear murder, they instantly think shooting somebody, stabbing somebody, bringing killed, deliberate premeditation. Her Honor will start doing the law.
Thank you, Laurie, too. Thank you so much, Laurie.
Clearly, we are not going to try to prove that Karen Reed tried to kill John O'Keefe. We're not going to try to prove to you that she intended or wanted him dead. That's not second-degree murder. What we'll prove to you is she engaged in an intentional act, driving back at him at that speed, in the storm, in the darkness, knowing that he had just gotten out of her Lexus. She intended that act would cause a plain, strong likelihood of death. That's what will be second-degree murder. Also, operating under the influence of alcohol, manslaughter will prove to you that she drove her Lexus recklessly. She hit John O'Keefe, and because she hit him and he fell back, she caused.
I want to play a little of him just so you could see the change between him to Jackson.
Again, she hit Mr. O'Keefe with a car. She knew he was injured. She left him behind. And got him. That's what we'll prove. This case will come down to the science and the data. The science and the data that cell phone is the best of historians. It doesn't suffer from intoxication. It doesn't suffer from memory loss. It doesn't suffer from emotion, pride, or prejudice. It is facts. It is data. And that facts and data will lead you to the truth in this case. But after Ms. Reed was charged, she began what you'll learn as a campaign. A campaign to make public statements. 2020, Nightline, Fox 25, a documentary. And we've had an opportunity to get many of her statements in the footage, and we're going to show much of it to you. And her statements to you will confirm what you already know from the science and the data, what you will already conclude from the facts independent about what she did that night. Her word is simply confirmed, and your judgment is sound. And you're going to hear from her own lips in many of her statements, her admissions to extraordinary intoxications, her admissions to driving the Lexus, her admissions to being angry at John that night. And I dare say her admissions that she told I'd like to play for you clip 1. You're going to hear the first of the statements that she made after she was charged.
I mean, I didn't think I hit him, but could I have clipped him? Could I have tapped him in the knee and incapacitated him? He didn't look mortally wounded as far as I could see, but could I have done something that knocked him out and in drunkenness and in the cold didn't come to again?
And this would have been the moment you dropped him off at the party.
Yeah, would have had to.
Ladies and gentlemen, I simply ask you to follow the evidence, follow the science, follow the data. Ignore speculation, surmise, conjecture. Stay true to the evidence. It will lead you to the truth. That on January 29, 2022, a very intoxicated defendant was angry and arguing about the relationship with John O'Keefe. And after the fight was over, she left, but she brought the fight back to him in the form of her SUV. She clipped him, he fell backwards, he broke his head, and then this man who helped, a lifetime of help, was left at the corner of that yard, left to die with no help. The facts, the data, and the evidence will bring you the truth, and the defendant's own words will confirm everything you've already concluded.
All right, thank you, Mr. Jackson.
Could I have just a moment to readjust?
Sure, the court officers will be kind enough to help you.
May I, Your Honor? The evidence in this case will establish above everything else 3 points. There was no collision with John O'Keefe. There was no collision. There was no collision. John O'Keefe did not die from being hit by a vehicle. Period. The facts will show that. The evidence will show that. The data will show that. The science will show that. And the experts will tell you that. You'll learn that the Commonwealth has pinned its entire case on a brazen and a flawed assertion that is untethered, unconnected to the facts and to the evidence. And their assertion is contrary to science. Because at the end of the day, folks, there was no collision with John O'Keefe. So how did we end up here? How does Karen Reed end up sitting in that chair on trial for an event that literally never happened? Well, the evidence is going to explain it. And it can be summed up in the following text message at the very beginning of this investigation. A text message of a now fired Massachusetts State Police officer named Michael Proctor. He was the lead investigator on this case, and he was talking about a fellow officer, a fellow cop, who owned the property where John O'Keefe's body was found. Text message with a buddy. Question: is the homeowner going to catch any shit? Answer: nope. He's a Boston cop too. That quote defines the lack of integrity of the Commonwealth's entire case, its entire investigation, and this prosecution. During the course of this trial, you'll learn much more about Mr. Proctor, why he said that, and what it really means. What you'll see and hear in this courtroom in the coming weeks is not just a story of a tragic loss. And make no mistake, John O'Keefe's death is and was a tragic and tragic loss. But the story you'll hear is about an investigation that was riddled with errors from the beginning, a rush to judgment, conflicted and corrupted from the start. Corrupted by bias, corrupted by incompetence, and corrupted by deceit. Finally, it was corrupted by a deliberate effort to avoid and to cover up the very truth that you are seeking. You'll find when you hear the evidence that the Commonwealth's case is the literal definition of reasonable doubt. They won't be able to talk their way out of it. They won't be able to explain their way out of it. They won't be able to excuse their way out of it. And they can't meet their extreme burden of proof, which the court will tell you is beyond any and all reasonable doubt and to a moral certainty. Members of the jury, Karen Reed found John O'Keefe dead on the front lawn of a Boston police officer, Brian Albert, at 6 a.m. on January 29th, 2022. Picture the scene. Blood-curdling screams, ambulances, emergency lights on, fire engines, ladder trucks, paramedics, patrol vehicles, patrol cruisers, police officers, first responders, firefighters, all swarming all over Brian Albert's lawn, literally feet under his bedroom window. Yet Brian Albert, a sworn peace officer, a first responder himself, never came outside. Never went outside to see what the chaos was about, never went outside to see if he could assist a man in need, never walked outside his house to see if he could help a fallen fellow officer on his own front lawn. More shockingly, you'll learn that lead investigator for the Massachusetts Police, Michael Proctor, never set foot inside Brian Albert's house that day. Never engaged in any investigation inside that house that day, even though a party with much alcohol had just occurred in that house, and even though a Boston police officer was found dead or dying just mere feet from the front door. on that lawn. He never secured the crime scene, never separated and secured witnesses. He never properly collected evidence. He never secured the evidence. He never searched for signs of a struggle inside or outside the home. He never properly canvassed the neighborhood. Michael Proctor never did any of these things, even though fellow officers of Michael Proctor's actually mentioned, in their words, not mine, that it looked like John O'Keefe may have been, quote, in a fight. You'll have questions about that conduct. During the course of this trial, you'll find that the Commonwealth will not have answers. You'll see from the evidence in this case that this case carries a malignancy, one that is spread through the investigation, it's spread through the prosecution from the very start, from the jump. A cancer that cannot be cut out, a cancer that cannot be cured. And that cancer has a name. And his name is Michael Proctor. Now, you didn't hear his name in the prosecution's opening statement. Not once. And I suspect that was probably by design. But make no mistake about it. The evidence will show in this case that Michael Proctor is the very definition of the Commonwealth's case. And he's also their Achilles heel. He was the lead investigator on the case officer, the architect of the entire prosecution. You'll learn there's not a single part of this case, folks, not a single part that he didn't touch, that he didn't direct, that he didn't orchestrate personally. Every single bit of it has his fingerprints on it. You'll learn that Michael Proctor was a longtime family friend of the Alberts. And he's been disgraced by his own agency, not by us, by the Massachusetts State Police. Investigated, suspended, and fired. The evidence will show that Massachusetts State Police found Michael Proctor guilty of bringing dishonor to the department for his conduct, not in some other case, not in some tangential case, in this case. The investigation of Karen Reed. Conduct that included bias in favor of his friends, the all-powerful Albert family, and bias against my client, Miss Reed, the outsider. Do you have any idea how hard it is for a state trooper to get fired? Well, the evidence is going to show that Michael Proctor earned it. Every bit of it. You'll hear that within hours of a Boston police officer being found dead on Brian Albert's lawn, Michael Proctor, the lead investigator, who had investigated exactly nothing up to this point, right at the beginning, made an early pronouncement that Brian Albert himself was not going to, quote, catch any shit, end quote. And that was for one reason, and one reason only. He's a Boston cop. The evidence will show that Michael Proctor made this statement in a text conversation with his high school buddies. A text he never thought would see the light of day, certainly never thought we would get a hold of. And when he thought no one was looking, he actually said the quiet part out loud. He's a cop too. We'll give him a pass. You'll learn that in Michael Proctor's world, rank has its privileges. And the evidence will show that's privileges that you don't get and I don't get. But apparently a Boston police officer, Brian Albert, and his friends, they do get. You'll learn that in Michael Proctor's world, he didn't care about finding the truth. In his world, his priority was to protect the brotherhood, to protect that blue wall, to protect his friends who were at the Alberts' house that night. I want to take a step back, if I could, and spend the next few minutes talking a little bit more detail about what the actual facts in this case will show, not based on speculation, not based on surmise, not based on guesswork or conjecture, but the actual true facts that you will learn through the course of this trial. On January 28th, 2022, it was a Friday night. John and Karen had made plans to meet up with friends for drinks. It was a happy and normal night for them. They were affectionate, they were loving, they were in good spirits, nothing out of the ordinary. They started at a local watering hole called C.F. McCarthy's. You've heard that name before and you'll hear it again. And eventually they made their way over to the Waterfall Bar and Grill, another bar where they ended up. When they got to the Waterfall Bar and Grill, the Albert family was already there, already heavily drinking. You'll learn that this was no ordinary family, the Alberts. The Albert family was a well-known Canton family. Some might even describe them as a very powerful Canton family. Brian Albert was there at the Waterfall. You'll hear that he's a longtime Boston police officer. His wife, Nicole Albert, was there with him. His brother, Chris Albert, a powerful Canton politician. He sits on the select board. The select board actually governs the police department, the Canton PD. He was there. His wife, Julie Albert, was there. Their daughter, Caitlin Albert, was there. His sister-in-law, Jennifer McCabe, was there. Her husband, Matt McCabe, was also there. They were all there drinking before John and before Karen ever arrived. You'll learn that a man by the name of Brian Higgins, also a law enforcement officer and longtime friend, longtime pal of Brian Albert, he was also there. And the two of them, the two Bryans, had been drinking most of the night together. You'll see video footage from the Waterfall, which will show you that Karen and John were happy. They were affectionate. They were caring. They were loving. Just business as usual, out on a date on a Friday night. But that exact same video footage which lead investigator Michael Proctor plainly chose to ignore that video footage. It paints a very different picture of Brian Higgins. You'll learn that Higgins had romantic designs for Karen. That becomes important. Brian Higgins had engaged Karen in flirtatious texts, but days earlier she had put a stop to it. She had ghosted him, in common parlance. In other words, just ignored him. The evidence will show that the first time he saw her and was in her presence after being rejected by her was when she walked into the Waterfall Bar and Grill along with her boyfriend, John O'Keefe. At 11:58 p.m., just minutes before John ultimately arrived at the Albert residence, you'll see a video at the Waterfall of an unsettling interaction, troubling interaction between Brian Higgins and John O'Keefe. And unlike the lead investigator, Michael Proctor, in this case, you won't ignore that evidence. As the bar was closing around 12 midnight, the Alberts invited everybody back to their house for a get-together to just keep the night going. And you'll learn that Karen and John ultimately pulled up to the house. They got out of the SUV to make sure they had the right address. You see, neither John nor Karen had ever been to 34 Fairview. They weren't even sure they were at the right address. And the evidence will establish that John got out of the SUV and went into the house. Let me say that again. The facts unequivocally, the data, the science, the witnesses will all unequivocally establish that John O'Keefe went into the Albert home that night. Eyewitnesses and forensic data will establish that fact. When he didn't come back out, you'll learn that Karen grew increasingly frustrated. She got upset. She was left alone in a car, in the cold, in the middle of the night, with the car idling. John had gone into the house. She expected him to come right back out, and when he didn't, seconds turned into minutes, and minutes started to clock away. She left John a voicemail, then another voicemail, voicemail after voicemail after voicemail, text messages. But he was unresponsive. He didn't pick up a single call. He didn't respond to a single text. The longer he didn't respond, the more upset she got. The Commonwealth will intimate, as they already have in their opening statement, that these voicemails are evidence that the two were fighting. The actual evidence in this case, however, will show the exact opposite. You'll hear that Karen was very agitated. You'll hear some voicemails where she's swearing. You'll hear voicemails where she calls him names. There's name calling. But you'll also hear the context of those voicemails. And every single one of them, every single one of those voicemails was left for John after he failed to come back out of the house, after he failed to respond to her voicemails, and to her texts. Karen believed John had just left her sitting there, grabbed a beer, was partying with his friends. The evidence will actually show that John and Karen never had a crossword, not a single crossword that entire evening before he left that SUV and went inside the house. And you will learn what Karen had absolutely no way of knowing at the time. It wasn't that he wouldn't respond to her. It's that he couldn't respond to her. And the evidence will show you why. To a doctor named Elizabeth Lopesada, a renowned forensic pathologist, a medical examiner, and a professor at Brown University. She will tell you that the injury to the back of John's head, first of all, was immediately incapacitating. And that has meaning. At the moment he suffered that fatal head injury, he couldn't walk, talk, grab his phone, cry for help, nothing. He was completely incapacitated, completely unconscious from the moment he suffered that injury. He was completely still and incapable of interacting with anyone or anything. But the doctor will tell you something more, and just as important. She'll tell you that John O'Keefe did not suffer from hypothermia, as the Commonwealth will undoubtedly allege. His body showed no signs of it. No frostbite, no cold-induced injuries to his organs, no damage based on cold or frost. Ladies and gentlemen, the scientific evidence and the medical evidence will establish that John O'Keefe had to be injured somewhere else, somewhere warmer, and his body had to have been moved out into the cold. And that's where, ultimately at 6 a.m., Karen found him the next morning. You will learn that John did not have a single injury consistent with being hit by a car. Let me say that again. The evidence will establish that John did not suffer a single injury on his body consistent with having been hit by a car. Not one. You'll learn that John's torso, his ribs, his chest, his arms, his hips, his legs, his knees, his ankles, his feet, all of them, no broken bones, no fractures, no contusions, no torn ligaments, no internal injuries, not even a bruise. Nothing consistent with a car accident, despite the Commonwealth's contention that he was slammed into by a 6,000-pound SUV. Not a bruise. Dr. Lopesada will tell you with medical certainty that, in fact, John was not struck by a vehicle. Medically and scientifically, he could not have been struck by a vehicle. Therefore, as I said, there was no collision. She will tell you that the patterned abrasions on John's right arm, the patterned abrasions you see over my left shoulder, they're not the result of being struck by a car or a taillight. You'll take one look at these injuries and you'll agree with Dr. Lopesada. The evidence will show that these injuries are from an animal, like a large dog, like the large dog that was inside the Albert house that night. You'll learn that Brian Albert has actually admitted that his large dog, the family dog, is, quote, not good with strangers. And of course, John, never having been to the house before, was a stranger that night. You'll also learn that oddly, very oddly, after having their family pet for 7 years, a short time after this incident, the Alberts got rid of that dog. They called it rehoming her. But she was gone. Dr. Lopesada will also tell you that the injury to John's head was not the result of falling backward onto a flat lawn, cold or otherwise. Rather, Dr. Lopesada will tell you with medical certainty that the injury pattern to his scalp was produced by an impact from a raised or ledged surface, a surface that does not exist on Brian Albert's front lawn where John was found. The medical evidence will establish no hypothermia, no injuries from a car strike, no collision with a motor vehicle. And forensic analysis of John's cell phone, Mr. Brennan mentioned that in his opening statement. The Commonwealth's own expert will ultimately support the exact facts that I just told you, including the temperature data. John O'Keefe was injured someplace warmer, and he was moved. That alone is reasonable doubt, but there's much more. You'll also learn that there were many people at that after-hours gathering at Brian Albert's house who would have left by the front door just feet from where John O'Keefe's body would have ultimately been, had he actually been there, right after 12:30 a.m., which is what the Commonwealth's claim is. There were nearly a dozen people who walked out that front door directly adjacent to the precise spot where John O'Keefe would have been lying. Not a single person, not one, not a single person, saw a 6'2", 216-pound man laying sprawled in the front lawn in dark clothing on a light white dusting of snow. Not one. Then the evidence will also show that every one of those same people drove by that same spot, not walked by it, drove by it to leave the house, and still not one of them saw John laying in the yard when they left between 1 a.m. and 2 a.m. in the morning. But you know who else you'll find never saw a body on that lawn? The snowplow driver, a completely independent witness charged with plowing the streets in Canton that night. You'll hear that Michael Proctor, oh, he's not done yet, Mr. Proctor. You'll hear that Michael Proctor wrote a report where he claimed that Fairview had not been plowed that night. You'll learn that that was completely false. That was a lie. Michael Proctor did not want any more witnesses. He didn't want the truth, and he falsely claimed that the road was never plowed. You'll learn that he wouldn't look for the plow driver, but we did, and we found, and we'll introduce you to, Brian Loughran. He plowed Fairview that night, and what he's going to tell you is that there was no body on that lawn at 2:30 in the morning. You'll learn that Brian Loughran passed by 34 Fairview, traveling right next to Brian Albert's front yard, and at 2:30 a.m., John O'Keefe was not there. But you'll see that the plow driver also provides some other troubling information, troubling testimony for the Commonwealth. You'll learn that after making that pass at 2:30 a.m., he showed up with his plow an hour later. He stopped at the entrance of Fairview. He was looking up Fairview to decide whether or not to plow it, but he saw an obstruction. At 3:30 a.m., he looked down the street, and in the very spot precisely where Karen would later find John's body laying at 6 a.m., there was a car parked in front of it, a Ford Edge. You're going to ask yourself, who's moving a car at 3:30 in the morning into a blizzard on the side of the road? You'll learn that Michael Proctor, the lead investigator, intentionally ignored this fact as well. He did no investigation to find out who owned a Ford Edge, but again, we did. And the evidence will establish that Ford Edge happens to be a favorite model of the Albert family. More than one Albert owned a Ford Edge at the time. You'll learn that those facts will add to the mounting and the overwhelming evidence that there was no collision and John O'Keefe's body was moved onto that lawn. You'll find that this is yet additional reasonable doubt in the case. You'll be introduced to science and physics, even from the Commonwealth's own experts. That science will establish that Karen Reed's SUV was not damaged by hitting a pedestrian, and conversely, John O'Keefe's injuries did not come from being struck by a vehicle. The Commonwealth mentioned triggering events, but what you'll actually learn from the experts, some of them the Commonwealth's own experts, is that a triggering event is not evidence of an accident. It does not evidence a collision. That's why we're here, a collision. And there's no evidence of one, zero. You'll also find that those exact sort of triggering events that the Commonwealth will rely on are relatively commonplace on Karen's SUV, and none of them are associated with a claim of a collision. Folks, the science will not lie, and the physics cannot lie. And that science will tell you with certainty there was no collision with John O'Keefe. You'll add that to that rising mountain of reasonable doubt. I want to take you back to the night in question, January 29th, for just a few minutes. Remember, Karen had gone home after dropping off John and John walking to the house. While Karen was asleep at home with John's 13-year-old niece, what were the people who had been at Brian Albert's house that night? What were they doing? While she slept, what you'll find and what the evidence will show is that they were extremely busy. You'll learn that after a long night of heavy drinking, Brian Higgins left the Albert residence, but he didn't drive home. Rather, he drove over to the Canton Police Department, where he kept an office at about 1:25 a.m. Not a Canton police officer, but he kept an office there. Why go back to his office at 1:25 a.m.? Why go back to the Canton Police Department at 1:25 in the morning on the night of a blizzard? You'll learn that while there, Higgins made a call at 1:30 a.m. Higgins will later deny that he made that call. You'll find that curious. And his explanation for that late night visit to Canton PD, you'll find that it changes nearly every time he's asked about it. You'll learn that after everyone left Brian Albert's house, Brian Albert actually claimed he had no contact with anybody else except his wife. No contact. Until he woke up the next morning. So he says. Then you'll learn that that, too, is a complete lie. His phone records established that he placed a call to none other than Brian Higgins at 2:22 a.m. shortly after Higgins completed that late night visit over to Canton PD. You'll wonder, what did they possibly need to talk about at 2:22 a.m. that night? The evidence will establish that Brian Albert called Brian Higgins first. Brian Albert then disconnected that call when Higgins didn't answer it. Seconds later, Brian Higgins returned the call. Brian Albert then did answer that call. They spoke for 22 full seconds, had a conversation, then they both hung up their respective phones. You'll learn that when they were asked about these calls and conversations, both Brian Albert and Brian Higgins lied about it. Both of them. They said they never had a call with each other. But then ultimately, when they were confronted with their own cell phone records and they could no longer deny the calls, they were asked independently, explain yourself. And they both came up with the exact same explanation. A butt dial. The evidence will make you question, why did Albert and Higgins speak at 2:22 a.m.? And why did they both try to cover up that phone call? You'll also learn after this incident and within days of one another, both Brian Higgins and Brian Albert, both police officers, both trained investigators, got rid of their phones. Both of them. And what else you'll learn Brian Albert got rid of? Shortly after this incident, Brian Albert got rid of his house, the whole thing. Just sold it. His childhood home, a home that had been in the Albert family for generations, he literally sold it mere months after this incident. Dog rehomed, phones destroyed, house sold. You'll learn that all these things happened shortly after the incident where John O'Keefe was found unresponsive and dying in Brian Albert's front lawn. And you'll also learn that Michael Proctor looked the other way. He did not investigate any of what I'm telling you. He pre-selected Karen Reed from the start, and he ignored everything and everyone else. Let's get back to what was happening with the others while Karen slept. What you'll learn during this trial is that Brian Albert's sister-in-law, you've heard her name before, Jennifer McCabe, she was at the waterfall that night, and she was over at the Alberts' house that evening as well. She left the after-hours gathering about 2 a.m., a little before 2 a.m., got home around 2 a.m. And you'll learn that according to the Commonwealth's own evidence from a forensic software program called Physical Analyzer made by Celebrite, it's considered the gold standard for forensic tools, you'll learn that a Google search was discovered on Jennifer McCabe's phone. A Google search that Michael Proctor and his investigators never revealed to us, but we found anyway. A Google search that was time-stamped, according to their own data, at 2:27 a.m. 5 minutes after that 2:22 a.m. call that Higgins and Albert denied having. And that Google search on Jennifer McCabe's phone read, Hoslong to die in cold. Hoslong to die in cold. Now, she misspelled the first word. Hos is supposed to be how, but the meaning's the same. How long does it take to die in the cold? Timestamped 2:27. And then that search was also noted by the same Celebrite program as having been deleted. The evidence will force you to ask, why is there a search on her phone? Why is it logged at 2:27 a.m.? When the Commonwealth claims that she first learned of John's death and where his body was hours later at 6 a.m. So what you'll learn is that while Karen slept, here's what was actually happening by some other very busy bees. 1:25 a.m., Brian Higgins makes an unexpected visit to Canton PD. 1:30 a.m., he makes a phone call that he later denies ever making. At 2:22 a.m., they both deny and lie about having made that phone call. 2:27 a.m., 5 minutes later, a Google search appears on Jennifer McCabe's phone, Hoslong to die in cold, hours before John's body was ever discovered. A Google search she denies making, and that she later, or at least it was later logged as deleted. Meanwhile, at 2:30 a.m., the plow driver confirms that O'Keefe's body was not on the lawn of Brian Albert's house, not at 2:30 in the morning. And at 3:30 in the morning, that area was obstructed by a Ford Edge like the one the Albert family liked to own. The evidence will show in the meantime, Karen dozed in and out of a fitful sleep for the rest of the night, only to awaken just before 5 a.m., and that's when she realized, in a panic, John had never come home. And you'll see, it wasn't like John to not come home. That morning, you'll see and hear evidence that Karen's emotions had morphed. It'd gone from frustration and anger, which you'll hear in the voicemails, to abject fear. Fear that something bad had happened. The evidence will establish by this time Karen was panic-stricken. She had a feeling something was very, very wrong. She was unable to get a hold of John. Karen went to go look for him. She got in her Lexus, and she backed up to leave her garage at One Meadows. You'll hear a lot about that address, One Meadows. That was John's house, where Karen was staying. She backed out of the garage, and during the course of the trial, you'll hear that she actually struck another car with that right rear taillight. During the course of this trial, the Commonwealth is going to desperately claim that Karen Reed's taillight was actually damaged by hitting John O'Keefe. They'll have no evidence of it, mind you, none, but they'll make the claim. We'll show you a video of exactly how that taillight was originally damaged, or exactly what happened at 5:07 in the morning. The facts will show that it was damaged in John's own driveway at 5:07 when Karen backed up and made contact with another car in the driveway. This is 5 hours after she dropped John off and he went into the Albert residence. As a result, the taillight was minimally cracked, but it wasn't completely shattered or damaged or broken. And that's the condition of the SUV when Michael Proctor got a hold of it. That becomes important. You'll hear from an independent police officer, an eyewitness to the damage on that SUV, someone not connected to Michael Proctor or under his control. And he'll tell you that he saw the taillight damaged before it was in Michael Proctor's possession, but it was not completely shattered. And you won't have to speculate how that taillight got cracked originally. You'll see it for yourself. It's on video. You'll learn that part of the reason that Karen's Lexus hit that car at One Meadows is because she backed out looking for him at a time when she was absolutely panic-stricken and grief-stricken. Where was John? Why hadn't he come home? What had happened to him? Is he hurt? Is he passed out somewhere? Her mind was reeling. The evidence will establish she wasn't giving anything away. Everything was on the table. What could have happened to John? You'll learn that when she woke up and he still wasn't home, she was just racking her brain for what could have happened to him, and she was worried about possibly the worst. He had gotten out of the car, he'd walked to the house, she was confused, and later, when she found him at 6 a.m. on the lawn, where she last saw him going toward the house, her mind started reeling, oh my God, did a plow hit him? Did I hit him? Could I have hit him? What could have happened to him? And that video clip that you saw, out of context, when she said the words, he did not look like he was mortally wounded, she's not talking about at midnight. She's talking about at 6 a.m. when she found him. That's what she was talking about. Your job will be to make sure that the evidence isn't presented to you too cute by half. She was saying all those things. Did a plow hit him? Could I have hit him? Did I hit him? She was saying that to herself and to other people. And the Commonwealth, very obviously, will try to seize on that panic and twist this into some admission. But here's the actual truth. That's not a confession. Could I have hit him? Did I hit him? Could a plow have hit him?
I just want to make a couple quick notes, and I want to thank everyone for watching, all of our moderators. There's about 10 more minutes left of this. Then I'm going to redirect everybody to Turtle Boy. Turtle Boy Live is on right now. Aiden Carney. Going to redirect everyone over there. I'm also going to throw in the Runkle Live right now if you want to go check him out as well. Let's do a Jerks raid on Runkle of the Bailey and Turtle Boy Live right now. So we're going to do both. You can do either or. But as soon as this is over, it's going to redirect directly to Turtle Boy Live. You can also check out Runkle of the Bailey. I'm going to put that link in there. Thursday night, we have Juna running for Norfolk County DA to replace Michael Morrissey. We saw a big thing tonight. The chief of police for Canton is resigning. It's because we all worked to get someone elected that didn't want her to keep her job. So now she's resigning. The people do have the power. So we're going to continue to work on it with Juna Perkins running for district attorney in Norfolk County to replace Michael Morrissey. She's going to be back on the show here Thursday night at 6:30. I'd love you to come back, check that out, hit the notification, come back, subscribe, all that. Friday night, we're going to have attorney Carl Steinbeck back on the show. I'm really looking forward to having him, criminal defense attorney. So we got a lot coming up this week, Thursday and Friday. Not sure if I'll do anything tomorrow night. We're going to be covering the Karen Reed trial during the day, though. But we'll see. You never know. There's going to be a lot going on this week. So we got a lot. Make sure you subscribe, follow us. Pinned in the chat right now, you're going to see our new email list, website. It's a blog as well. Hit the link. Make sure you subscribe. Put the email in there, please. We got a lot more that we're going to be doing on that website as well. So I'm going to finish this off tonight, and then I'm going to redirect you. Please come back on Thursday. We'll see you Thursday, definitely. And tomorrow morning, we'll be covering Karen Reed again from court.
That's a person trying to make sense of an unexplainable circumstance, a natural concern of a bereaved significant other, a woman desperately trying to piece together what could have happened on this tragic night. John didn't come home. And the evidence will show that Karen Reed never said, I hit him. Never. Not in the background of the 911 recording, not on any dash cam video, not on any audio.
Of course, I wanted to come up because I realized I wanted to make a couple more comments. I'm sorry to do that to you. But here's one. Julia said, any chance you'd be willing to run upstairs real quick and set up for redirect for Runkle? I've already got it set up for Aiden, Turtle Boy, but going to put Runkle's link in there. So we're going to redirect to Runkle as well if people want to go check him out. And I want to acknowledge Heather. She said, thanks, Mike, for airing this. I've missed a lot. Been sick since February. She was in the ICU. Oh, my God. I'm back now, and I can't wait for round 2. Good to see Officer John O'Keefe's dad in the gallery. Love. Thank God you're out, Heather. I'm glad you're out, and I'm glad you're ready to go for round 2. I am as well. This last couple of months, I've been complaining about how busy I have been at work and my schedule. And just this week, it's been so slow. It's been perfect for me. So I can watch this whole thing. Things work out just at the right time sometimes for you. So let's watch the end of this, and then we'll redirect to Aiden and Runkle of the Bailey.
Not on any police body cam, not to a first responder. It's never mentioned in a single report. It's never reported in a single report from January 29th, not by one person, because it never happened. The evidence will show that members the evidence will show that there were at least 13 members of law enforcement or first responders and 2 civilian witnesses that were intently focused on what was happening at that scene. They were all over the lawn. They were all over Karen. Officer Sarath, Mullaney, Good, Lank, EMT Nuttall, Flamati, Kelly, Walsh, Woodbury, Whitley, Becker, Robery, McLaughlin, Carrie Roberts, Jennifer McCabe. They were all there, watching and listening. On January 29th, when John O'Keefe was found, not one first responder reported having heard Karen Reed say the words, "I hit him." Not one. Not one civilian reported having heard Karen Reed say, "I hit him." The facts will show that the first time this improved statement was ever claimed to have been made was some 24 hours later by a single EMT in an interview. Now listen to this. In an interview coordinated by a Canton police detective named Kevin Albert, Brian Albert's brother. And remember, Chris Albert, the other brother, is a board selectman to whom the Canton Police Department reports. And what's more, you'll learn that Katie McLaughlin, that's the EMT, that's the single EMT, the first person to have claimed to have heard this unrecorded and unreported statement, is years-long close personal friends with a young woman named Caitlin Albert. You heard that right. It's Brian Albert's daughter. During the course of this trial, you'll become familiar with and you'll realize that the Alberts are indeed a powerful and indeed an influential family, and that will mean something. You'll learn that there are other major problems with the prosecution's case. The evidence will establish that Michael Proctor himself, the lead investigator and architect of this entire case, has a long-standing and personal relationship with the Albert family. Yes, that same Albert family. His sister was close friends with Julie Albert. He personally sat at head tables at weddings, or at a head table at weddings with the Albert family. He entrusted the Alberts with babysitting his own children. You heard that correctly. And yet he was the lead detective assigned to investigate the circumstances of a Boston police officer laying dead on the Alberts' front lawn. That's not just bias, you'll learn. That's not just coincidence. That, folks, is corruption. And you'll see how far it went. Michael Proctor was alone with all the critical evidence in this case, alone with Karen Reed's phone, alone with John's phone, alone with video footage, alone with the taillight material, alone when he claimed to recover evidence from 34 Fairview. He wrote the search warrants, he transported the evidence, he secured it, he submitted it, he did it all. That's Michael Proctor. And he did it without any reasonable oversight. You'll see during the trial that he intentionally lied and fabricated evidence during the course of this investigation. He lied in reports, warrants, he lied under oath. He lied about the time that he actually secured Karen Reed's vehicle. Why? Why would he lie about that? The evidence will give you the answer. He lied because he did not want it revealed that he had access to that vehicle and he had access to that taillight before any taillight fragments were found at 34 Fairview. Appreciate that. He had access to the vehicle before a single piece of taillight material was ever found at the scene. You'll find that there were 2 searches. The first and second search found 0. Nothing. Nothing around John's body. Nothing in the street. Not one piece of taillight fragment. But once Michael Proctor had that SUV and had the taillight in his custody and control, suddenly items started magically showing up. And not just a few items. 46 pieces of bright red taillight laying in the snow, supposedly found in the exact same spot that was searched not once, but twice by independent officers. Came up with 0. To be clear, you'll learn that before Michael Proctor had access to that taillight, not a single piece was ever recovered at 34 Fairview. That will become vitally, vitally important. And what about those shards of plastic, by the way? What about this DNA that the Commonwealth mentioned? They're going to try to dazzle you with talk of DNA because it sounds so scientific. DNA was on the taillight, but you'll learn that there was no DNA on the actual shards that they claim came in contact with John's arm. None. There was no blood, no tissue, no skin, no DNA on a single shard of plastic that they claim cut deep abrasions into John's arm, the arm that you saw overhead. The DNA that was actually found, the actual science will show, was found outside of the taillight housing where anyone with access to that vehicle would have touched. And it wasn't just one male's DNA. In that exact same sample, there were 3 men found, John and 2 unidentified males. So unless the Commonwealth is going to shift their theory that that SUV hit 3 men that night, their entire theory falls apart. And speaking of DNA, the evidence will further establish that John O'Keefe's shoe, the one that he was wearing when he was found, was sampled. And that DNA revealed 5, count them, 5 unidentified males. Recall that the evidence will establish independently that John was injured someplace warmer and had to be moved onto that lawn. 5 unidentified males touching that shoe. You'll also learn that you are not the first person, not the first to hear about the Commonwealth's theory of this case, that John was hit by an SUV. That's their theory. The Commonwealth presented this exact same claim to their own medical examiner, a woman by the name of Dr. Irini Scorti-Bello. And you'll learn that after reviewing what's called a law enforcement accident notifier, with law enforcement's theory of the collision written in it, defined in it, after conducting the autopsy herself, after examining John's injuries in detail, she refused to conclude that John's death was a homicide based on the Commonwealth's presentation and their theory. That's right. The Commonwealth's own medical examiner will not deem the manner of death in this case, a homicide. She won't do it. But they're nonetheless back again trying to present the exact same theory to you in this trial. Again, the evidence will show that that is reasonable doubt. Throughout this trial, the Commonwealth will try to convince you of paranormal events, phones calling themselves, messages deleting themselves, Google searches made and then unmade, evidence magically appearing and evidence magically disappearing. But all that smoke and all those mirrors will not ever reach their burden. Because that's what this case is ultimately about. It's about the Commonwealth's burden of proof. You'll learn that during the trial, the Commonwealth bears the highest burden known to our justice system. They must prove every element of every charge beyond a reasonable doubt and to a moral certainty. And you'll learn that moral certainty means the highest level of certainty known in human affairs. It's not a small thing. They're not going to be able to do that. Not when every piece of this case was handled by a disgraced investigator with a motive to protect his friends, not when the physical evidence contradicts their very theory, not when their own medical examiner won't call this case a homicide based on the exact theory that they're presenting to you, not when the conduct of those in the house and the utter lack of investigation speaks volumes about those who actually have something to hide. By the end of this trial, you'll conclude that Karen Reed is not guilty of hitting John O'Keefe with her SUV. There was no collision. She's the victim of a botched and biased and corrupted investigation that was never about the truth, folks. It was about preserving loyalty. You'll find that this case is the very definition of reasonable doubt. And at the end of this trial, we'll ask you to return the only verdicts, all 3 of them, that are consistent with the evidence, the science, the truth, and justice. Not guilty, not guilty, not guilty. Thank you.
Thank you, Mr. Jackson. Folks, why don't we take our morning recess?